Being after 9, I'm going to call the House Judiciary Committee to order, and I'm first going to recognize Representative Rombo to lead us in the Pledge of Allegiance.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Representative Birch reminds me that we're waiting for a clerk. I got a text from Representative Petronil. She's on her way. So Representative Birch, would you like to fill in on a short-term basis?
I have no idea how to do that. I'm sure.
Wait, Representative Kutab is not here either. So, well, you know what? Actually, let me hang on one second. Let me get some note paper. I was a clerk in finance my first term, so I
But this is your bill too, Mr. Chair, so you gotta go over there.
Right.
Oh, yeah, no.
You can't clerk or chair or do anything.
Yeah, exactly.
So
You have to sit in this seat to share.
no, you can share. You can share. So I unfortunately, since it is my bill, and since therefore I can't be the clerk, we're going to recess just shortly until Representative Petronil arrives.
Clerk is up to speed. You ready? Yep. Okay.
Just filling out cards and
Hope I can read your name. Okay, I'm going to open up the hearing on House Bill 520 relative to authoring hearings offices of the Department of Education to issue subpoenas, and I recognize Representative Lynn to introduce the bill.
Thank you, Mr. Chair, members of the committee. This bill has been, or a version of this bill has been before this committee before last year specifically, and I think maybe the year before that too. It basically is a bill to authorize the Department of Education to issue subpoenas in connection with investigations and/or hearings related to investigations of the Code of Conduct for New Hampshire educators. The bill uses, for lack of a better term, I would say the bill uses what I would describe as sort of standard subpoena language, and it's designed to allow subpoenas to be issued both during the investigatory stage of an investigation and then for subpoenas to be issued in connection with any adjudicatory proceedings that may result from the investigation. My recollection is that there were some assertions made during previous iterations of this bill that this was that what was being proposed here was really highly unusual, that it was not that this was not something that was sort of standard in either the education context or in administrative law generally, which was contrary to my understanding of how the law worked. But I had occasion, and I know Representative Kutab will be here before long. She actually did some. She actually spent some time doing some research on this, and apparently every other state in New England. And I spoke to her this morning. She quoted Connecticut. Connecticut has a statute that is virtually not. I wouldn't say in wording, but in terms of purpose, it basically says the Commissioner of Education can issue subpoenas for investigations. And in fact, I don't think there it's even limited to investigations of teacher credentialing. I think it's just basically anything that's within the jurisdiction of the Department of Education that they have authority to investigate. And again, according to Representative Kutab, that's the situation throughout New England. I would be very surprised if it wasn't the situation, in most states. I mean, again, if you're going to give an agency the authority to investigate, and if you're going to give an agency the authority to hold hearings and take some kind of disciplinary action, it just makes sense that they ought to have authority to issue subpoenas, because otherwise, just stop and think of it. The equivalent, it's not limited to the education department, but this is the equivalent, the administrative equivalent, whether it's the education department or the Department of Environmental Services or whatever, Department of Labor. This is the equivalent, the administrative equivalent of a trial. There's of an investigation let's say that would be conducted by the Attorney General's office or a county attorney's office. And they have to have the ability both to compel witnesses to appear and compel the production of documents in the investigative stage, and then they have to be able to compel both sides, both the proponent or the prosecution, so to speak, whether it's civil or criminal, and the defense have to have the ability to compel witnesses to appear at the hearing. That's really all that this does. It has provisions in it that allow for a party that's subpoenaed who thinks the subpoena is overbroad to move to quash the subpoena or to limit the subpoena. To the extent that there's a claim that this is somehow unfair or unprecedented, I submit that it's just not correct. So I'm happy to answer any questions. I think it's a good bill, and I hope you'll support it.
Representative Smith?
Thank you. Good morning. Can you tell me who provides legal representation for the Department of Education in Connecticut?
Who provides legal representation? I don't know, but I know they have an Attorney General's office. As I recall, in Connecticut, the Attorney General's office is limited, unlike in New Hampshire, is limited to handling civil matters. Mm-hmm. But I suspect that it might be that when the when I don't know this, but I'm speculating, I think this is probably, informed speculation, that the Department of Education handles things internally within the Department of Education, but if they have to go to court, then it would be the Attorney General customarily is the agency that represents the state or its agencies in court. So I would suspect that would be the case in Connecticut.
Thank you very much. I'm not going to do what I'd like to do, which is to ask you the same question about Massachusetts, Vermont, Maine, and anybody else I might have. Rhode Island. I didn't want to forget Rhode Island, of course. Is it not true, Mr. Chairman, that in the state of New Hampshire, which likes to do things its own way, it is the Attorney General that provides legal representation for the Department of Education?
When you say provides legal representation, I think I guess I need to know exactly what you mean by that. I think it is certainly true that if the Department of Education is going to have to appear in court, that it's the Attorney General's office that does the representation. But I think that's true really for any agency. Maybe there's some exceptions, but I would be surprised. I think generally the Attorney General provides the in-court representation for agencies. But I think this is not dealing with in-court representation. It's dealing with administrative proceedings. And I think in administrative proceedings, it's not at all unusual for the agency to handle its own administrative proceedings.
Thank you very much. I believe that what has historically been true is it's the Department of Justice that has handled those responsibilities for the Department of Education, but you're the expert. I'm not. Thank you.
Representative Page.
Thank you, Mr. Chair, and thank you, Mr. Chair, for taking my question. I guess on both sides. To paraphrase Yogi Berra, this is like deja vu all over again. I remember the origins of this bill coming from the Divisive Concepts Bill and empowering the Commissioner of Education to prosecute cases on behalf of parents that alleged there was some violation of that, and I lost track of that, but it's somewhere, I think it's enjoined in the First Circuit or something. I've lost track. But in any event, in the multiple rounds of testimony on that, we had the Department of Education investigator come and testify, and he said he was doing a great job at his job in terms of policing, for lack of a better term, teachers that may be up for losing their license. And as I recall, he sort of suggested this would be another tool in his toolbox to get this. But he didn't indicate that there was a problem we were trying to solve. And so I guess I'm putting my little conservative hat on again. Less government is more for me, but I'm wondering, has there been any indication from the department that they are unable to do their job since the last time we heard about this to now that they would need this power?
Have I heard something since the last? I guess I have to say my recollection of the earlier testimony. I mean, I think I largely agree with what you said. The investigator from the department, I think he was, if I recall, a former state police officer. I think he did say, as you indicate, that there generally has been no problem in getting information. I think he did say that there, if I recall, that there were a couple of instances where there was a timing issue of things getting delayed more than he would have been comfortable with. But I believe we heard testimony from some witness, and I can't tell you who it was, that indicating that there were some school districts that were simply saying, we're not giving you the information. Now, whether that, the exact context of that, I don't remember, but I do remember that there was some testimony to that effect. So, I guess what I would say as a response to your question is, I think it makes sense for, as I said before, if an agency has the authority to conduct investigations and to hold hearings, it just makes sense that they ought to have a power to compel people to comply. Somebody shouldn't be, if the Department of Education is conducting an investigation of an educator, and wants to get documents or records or witnesses, the respondent shouldn't be able to say, go pound sand. And without a subpoena power, that sort of effectively is you give them that authority. And I don't think they should have that.
Representative Bergeron.
Thank you, Mr. Chair. I just wanted to ask simply, I wish I had somebody in front of me that has experienced this process, because at this point, I don't feel like I have enough information because I don't know typically what happens to the parties. Because here it says any cost incurred issuing a subpoena is the responsibility of the party requesting it, unless determined, there's an unless there that bothers me, determined by the officer, by the truancy officer, I don't know. But that's what I'm feeling comfortable on. I feel like we're all kind of know a little bit about it, but I feel like I don't know enough.
Okay.
And I've been on a school board for 12 years. So,
This is a time for questions.
yeah, I'm done.
Oh,
I just wanted to say that I'm uncomfortable about it just simply because I don't feel like I have enough information.
All right. Representative Birch.
Thank you, Mr. Chair. Mr. Chair, I'm following up on your analogy of this to a trial, which in some respects it is. Unless I'm missing it, it's true that under this bill, one side gets to subpoena and the other side doesn't.
No.
That seemed we're here in the bill. Did I miss saying that all parties have a similar right?
So, right. So I think here's the analysis. If you look at sections Roman numeral 13 in section 1 of the bill, and you go from 13A through 13D, I'm sorry, 13A, 13A through 13D. Those are the paragraphs and subparagraphs that deal with what I would refer to as investigative subpoenas, which would be issued only in favor of the party conducting the investigation. And I draw the analogy to the grand jury. The state can subpoena witnesses to the grand jury. The defendant doesn't get to do that. Doesn't have subpoena power to subpoena people to the grand jury. Paragraph E says that any information that is gathered during the investigative process shall be made available to both parties at the proceeding that may result from the investigation. And then particularly paragraph F says that in any adjudicatory proceeding, a hearings officer may issue subpoenas to both sides. So that's the equivalent of the trial subpoenas, if you will.
Assuming that there's basically two sides here, you've got the Department of Education and the person being teacher, whatever, being investigated. If I understand your answer, that the one side, whether it's at the grand jury level or later adjudicatory level, has the sole authority to collect the information. That information must be shared, but the information is limited to what the Department of Education wants to produce and does not cover what the teacher may want produced. Is that correct?
Well, if you're saying during the investigative stage,
In either stage.
well, I think there's a big difference. In the investigative stage, it is certainly true that, and again, I draw the analogy to the criminal process, but I think in any sort of administrative process, it would be the same would be true. In the investigative stage, it's the body that's doing the investigation that has the authority to compel people to comply. Now, if a respondent knows that they're under investigation, and I suspect it would be a rare case where they didn't, Can they ask people to voluntarily provide them with information? Of course. But I don't think, and you correct me if I've missed something, but I don't think in any criminal process that I'm aware of that during the investigative stage, the defendant or prospective defendant gets to subpoena people to come where? There's no case. So they don't get to subpoena people to come to the grand jury. That's for
I don't
sure.
want to belabor the question, but when it moves to the adjudicatory stage,
Right.
the evidence that the Department of Education wants and people want is available,
Right.
but there's no subpoena power for the accused, so to speak, to have the equivalent ability to subpoena documents and people.
No, that's not true. That's exactly what subsection F says. If once you get to the adjudicatory stage and there's a hearing, of course the respondent, the teacher, can of course ask to have subpoenas issued for, exculpatory evidence or evidence that favors a defense. Of course they can do that. That's
right.
what F is designed to cover.
Okay, thank you.
Representative Andros.
Thank you, Mr. Vice Chair, and thank you, Mr. Chair, for taking my question. As a citizen, I've had several dealings with DOE, and I've always been told what a matter I take to them, that we do not have statutory authority. Just what statutory authority does the DOE have to do investigations?
I have to say that as I sit here right now, I know that they have the authority to do investigation of the credentialing of teachers and whether or not they have violated, the credentialing statutes. I assume that they have other, authority to do investigations. I mean, for example, if they thought that somebody they had a contract with was not being, was not complying with the contract or something, I would assume they could investigate that. But without having looked at it, I believe we have a witness here from the Department of Education who probably is much more familiar with that and could answer it. So that, I think I guess I would say the best I can tell you is I would assume they have investigations to do in other, authority to do investigations in other areas, but I don't know that for sure.
Okay, thank you.
Representative Horrigan.
Thank you very much, Mr. Chair. Thank you. And thank you very much, Mr. Usual Sheriff, for taking my question. So this, as I see in obviously in line 5 and 6, it's limited to one particular aspect of what the DOE oversees, which is the code of conduct for New Hampshire educators. And just glancing quickly at the law, it looks like that's not just teachers, but paraprofessionals, and everybody works directly with students. But why do we exclude other people and entities that DOE works with, such as, we've had issues with, you mentioned vendors who provide services. We had some somewhat controversial organizations, for example, providing course materials to the schools. Also, we've had issues with, we often have many charter schools are often founded and failed. So you often wonder, I don't think there's been any criminal cases as a result of those. But we do wonder, about, you might have a situation where you want to investigate that. And then, of course, you have the EFA program, which the administration was turned over, to a small nonprofit organization based out of state, and there's very poor oversight of it. But you could certainly imagine, and there already was some waste, fraud, and abuse found in a very limited audit. So, with this, why doesn't this give the DOE the authority to subpoena those three types of entities: vendors, charter school boards that fail, and the EFA scholarship organization?
I'm really very glad that you asked that question, Representative Horrigan, because my recollection is that way back when, a year ago or 2 years ago, when there was a first draft of this legislation, it was broader. It said that anything that the Department of Education, I'm summarizing here, but my recollection is it would have given the Department of Education broad subpoena power to issue subpoenas in connection with anything that they had the authority to investigate. And my recollection is that people on the loyal opposition side of to this issue were very concerned about that. Oh, this is much too broad. It should be limited to teacher credentialing, and so that's what this does. It limits it to teacher credentialing. And so that's the short answer to your question. It's done that way in the hopes that that would eliminate the objections of some people that objected to the subpoena power being too broad.
Fair enough. I think I did vote
Representative
against that
Morton.
legislation.
Thank you, Chair, and thank you, Chair, for the question. It's actually a similar question. So when it says New Hampshire educators, is that only public schools, or he mentioned charter schools, but also like, private colleges and things like that? Is that included in New Hampshire educators?
Yeah, I believe as I understand it, it's educators that have credentials. Now, my understanding is that educators that have credentials are not limited to public school teachers. So if there's a claim that a credentialed educator who was not teaching in a public school came under investigation, then this would apply.
Any other questions? Representative Turer?
Thank you, Mr. Chair, and thanks for taking the question. Thinking back to the last time we heard the similar bill, I think one of the takeaways that I recall was that this can already be done through the Attorney General's office, so maybe it builds on the question that Representative Smith started off asking. Is there a problem in which this can't be done through the Attorney General's office currently? In other words, is it necessary to set up this whole separate structure?
Well, I guess what I would say is this. I think if your question is, could the Attorney General take over, if you will, the sort of, the investigation of teacher credentialing by the Department of Education in some particular case? Could they do that? I think the answer is probably they could. I would defer to Representative Fortin unless there's something in the statute that I'm just not aware of right now. But I would think the answer to that is probably yes. But I think I think that would be true really of almost any administrative investigation. I assume the Attorney General would have that authority if they wanted to. But to me, I think that's not an appropriate answer, because the agencies themselves, they conduct these investigations internally, and they should, at least in my view, they should be able to do that.
Can I do a follow-up?
Yes, follow up.
So just to clarify, what I was really asking was just about the subpoena. I understand that the Department of Education would be the one that would have to investigate the actual underlying matter. I guess the question is, if they were running into a roadblock and they felt like, compulsory participation was needed, my understanding is they could go to the Attorney General's office to seek just the subpoena, not to turn over the whole process.
Seek just this. Well, I think, I guess, as I'm thinking this through, I think that without some authority giving the authority to compel the production of documents or witnesses in connection with an administrative investigation, I don't think that the Attorney General could do that. I think what the Attorney General would have to do, I think, would be to go to court and seek a subpoena from the court, because I don't think that there's a statute that generally gives the Attorney General the authority to issue subpoenas in education matters. I think the Attorney General, I definitely would agree the Attorney General could go to court and petition for the issuance of a subpoena, but it seems to me that, just as we talk about that would be a pretty cumbersome procedure. In other words, you'd have, imagine if that were true just throughout the administrative regime. So that, the Department of Environmental Services, they're conducting an investigation. They want to get records. They have to go to the Attorney General's office to go to court to get the records, or the Department of Labor or whatever. It just seems like that is a kind of an awkward procedure to place any agency in. where they're conducting and have the authority to conduct their own investigations.
Representative Birch?
Thank you. I notice, and this, I'm wondering if you would accept or think it wise for an amendment. I'm noticing in section F, as you point out,
Yeah.
a hearing officer may issue, okay? May or may not, no standards. If you go to section A,
Right.
it's a shall issue with a few caveats. It's got to be good faith and likely to be material. Would you have an objection to an amendment to F that changes the may issue to a shall issue under the same criteria as earlier, so that, I mean, I understand the hearing officer is part of the Department of Education and may just have a point of view about relative merits and the like. A shall issue is more protective of the, I don't want to use the word accused, but you know what I mean,
Right.
rather than being, may get a subpoena issued, may not, without any standards.
Yeah, you know what? I guess what I would say to that is this: I would have no problem with changing the may to shall if you added language that said, for example, shall issue the subpoena for the attendance of witnesses or the production of books, papers, documents, and other items on behalf of the department or the certified educator. If we put language in there saying, you know, shall issue subpoenas for materials relevant and material to the, because I actually think that if the shall in subsection A with the two then caveats of what has to be shown is kind of the equivalent of the may. I mean, it's not, I agree, it's not exactly the same, but it does, the caveats in 1 and 2 under subsection A are sort of turn the shall into, well, shall, as long as you satisfy these things. I think that to me, that's roughly the equivalent of the may in F, but I wouldn't have a problem with changing it to shall if you put in, it's got to be material and relevant, because otherwise you can't have, you know, either side shouldn't be able to ask for a subpoena for just anything.
Thank you.
Representative Bergeron?
Thank you. I was just curious, because usually a school district or a school itself would be involved in this, and I don't see anywhere here how or if they need to be communicated in a certain way. So I'm just confused if you know anything about the fact that where does a school district or a school, whatnot, fall in this?
But as I understand it, the credentialing investigation proceedings are directed against a credentialed educator. Now, obviously, that person, or I shouldn't say obviously, but in all likelihood, that person works for a school district. And presumably, one of the likely places I would think that a subpoena, particularly for books or records and other kind of things, might be issued would be to the school district. So that's, I think the way that they would be involved is if the subpoena was issued to the school district to produce certain books or records or payroll records or whatever, curricular records or something like that. I would assume that then the school district would be involved in that way.
Thank you. Any other questions? Seeing none, thank you.
Thank you.
Brian Hawkins.
Thank you, Mr. Chairman. Members of the committee, for the record, my name is Brian Hawkins. I'm here representing NEA New Hampshire. We represent thousands of educators across the state in collective bargaining and some in these sorts of proceedings. Although I don't conduct these representations myself, I'll do my best to answer any questions that you have after my testimony, and if I can't answer them, I'd be happy to get you the answers to those. But this is, I think, the third time we've had a similar bill in the last few years. We are still here in opposition to the bill. We feel first, the first question the committee should answer before even examining the language of this bill ought to be, is it necessary for the Commissioner of Education or the Department of Education to be able to obtain subpoena authority to properly carry out their charge under the New Hampshire Educator Code of Conduct? And as was noted earlier, in subcommittees, in hearings, the department has consistently told the legislature each time the issue has come before you that the authority was a prospective need if there were documents that a school district simply would not allow them access to. The question of whether there were documents not being made available to them was asked in, as I said, a retained bill subcommittee meeting, follow-up conversations, and the bill heard last year in committee. As far as I could tell, and I'm happy to be corrected, the answer was still no. And there was not anything that the department could not view in determining whether to recommend whether a violation had occurred and a punishment was warranted. So, and to the bill itself, we still feel that this is fundamentally unfair with respect to credential holders' due process rights. First, I'll bring up a couple of points on this. First, the department essentially is asking for the ability to issue subpoenas to solicit information during investigations. Yet, as was again noted earlier, there was no provisions that the subject educator may also issue subpoenas which would assist in their defense during the investigation period. I think that's important, partly because, as I've been told, the experience here is the investigatory phase that this rarely gets to an adjudicatory phase. And so most often that is the phase that we are talking about. And so when you're talking about being able to have the information necessary to make decisions about whether you're going to accept a recommended sanction from the department, having all of that information is critical to the credential holder. In the rules, I don't have the specific timeline in front of me, but there is a prescribed timeline that an educator has to make that decision that involves their career as to and having an adequate amount of time to and information to make that decision is really critical. And so that's one of the areas where I think that it's not necessarily an apples to apples. Just because one state has subpoena authority for their education department, we should too. The processes are different. The experience is different, and so the department, of course, will have all that information well beforehand. So as before, the language is not restrictive to certain code of conduct violations, and subpoenas in the investigatory phase based on these standards brings us back to concerns about how broad they are. For example, in the criteria that for the hearings officer, it states that the material would be reasonably likely to be material. We think that's broad, and so we're concerned that that could mean anything and everything. I'll close with just some context for this legislative session. Last year, we were also, part of the reason we were concerned about adding this authority to the departments was because there was a simultaneous process going on to change the rules, the investigatory proceedings and procedures under the Code of Conduct through the rulemaking process. And so we were doing two simultaneous processes. One, we were changing the rules, and then we were also adding this additional authority. And at that point, we didn't know what authority we were adding for subpoenas we were adding to, what process we were adding that authority to. So, but this year, I think it's important for the committee to understand there's also several attempts to expand the educator code of conduct going on in other committees. And so I think that's important when you're talking about broadening the scope of the code of conduct. Across the hall, where I spend a lot more time than in the Judiciary Committee, the House Bill 235 would allow the state board to write an entirely new category of unnamed responsibilities to the code of conduct. Senate Bill 96, being heard in the Senate, around mandatory disclosure, also contains subjective and vague standards for divulging information in response to written inquiries. And that bill also contains language saying it must be added to the educator code of conduct and be considered a violation of the code of conduct. So for those reasons, we have concern that this bill is, as I said, unnecessary. And I would urge the committee to also look at those other factors when considering whether we need to grant this authority when we're not sure what kind of educator code of conduct we're even talking about by the end of the session. So I'll close with that and happy to take any questions that I can.
Okay, so I guess I have a question.
Yep.
As far as subpoena power for both the Department of Education and the respondent, it sounded like from your testimony, you agree that subpoena power is important, critical, to get accurate and thorough information, however you want it for both parties. But it sounds like you agree that that's critical, though, to have that power.
Yeah, thank you for the question. And if let me clarify. I don't think that this is a necessary power for the department to have. My comments about both sides really had to do with within the context of this specific bill, not generally whether that power is necessary.
Representative Perez?
Thank you. Thanks for taking my questions. I have two quick questions. I'm going to give a 2-second thing. I was a registered nurse who had a license, and I was subpoenaed twice to speak in an incident that occurred with another nurse. And I wonder why you think that's any different. And my second question is, have you heard of sealed, what do you call them when something's sealed? Sealed documents?
Yes.
Where something has come up in a school with an educator or an employee, and they have been given, and in businesses where they have been given the option of, well, you have a choice. We'll either fire you or you can quit and we will seal the documents, the complaint. Those are my two questions. Thank you.
Sure. Well, taking the second one first, I mean, I am familiar that sometimes in employment situations you have those sorts of arrangements. I know there have been bills that specifically deal with that, but I'm not sure that it's necessarily relevant to this bill, although I would say, it at least as I can see it, it doesn't seem as though there is, I think there's a question about what could be subpoenaed here. So, whether that's included, whether you're talking about any, are there items that are exempt under 91A from disclosure that are also being able to be subpoenaed? I think that's unclear from the bill. And then to the question around other professional license with a nurse, I think that it's a different situation here. there was authority granted to, I guess in that case it would be OPLC or Board of Nursing, I guess, not to the Department of Education. I think, if anything, the track record in the last several years and beyond, I think should give pause about whether we're allowing an innately, at times, political department to be able to issue subpoenas. And I know that I know a lot of you probably won't agree with that, but I think that's a reason to give pause about whether you ought to grant this authority.
Follow up.
What do you mean by track record?
Well, I mean, I'll be happy to share the there was a story not long ago about the track record of the commissioner and the use of authority to drive a certain agenda. And so I don't think that is, I think that should give the committee pause when it comes to subpoena authority, one, but two, when it comes to subpoena authority in any code of conduct violation. Like I said, when there are numerous bills this session that are proposing to expand the code of conduct.
Might I, for the record, say that I feel that that was a very inappropriate remark, bringing up the track record of the Department of Education.
Yeah, we don't really speak about motives, but Representative Morton.
Thank you. Thank you for the question. And when we talk about track records, I'm not going to look at the test scores that we have in the state. That being said, as far as my career, I'm regulated by the insurance department here in the state. I'm regulated by the SEC and the FTC. Why shouldn't educators be? Shouldn't there be better oversight?
Well, the educators are regulated under.
Well, not saying that they're not regulated, but why shouldn't there be better oversight? Because that's what this is about. I mean, you spoke for about 5 minutes and said like 2 words.
I'm not sure this question there, Mr. Chairman, and so I'll.
Okay. Representative Manos.
Thank you. Sorry. Thank you, Mr. Vice Chair, and thank you for taking my question. You spoke about pending changes to the rules of the Department of Education, and as I was wondering whether those rules have been finalized and whether any of them impact the issuance of subpoenas or any of the issues that we're dealing with here.
There was a finalized rules changes in the investigatory process that were finalized last year. I'd be happy to send those to the committee. They deal with a variety of issues from timelines to notice around to the credential holder when they're under investigation, and what that notice needed to include if they are placed under an official investigation. So it deal with a variety. I think they are in some cases connected, in some cases, indirectly to the subpoena authority.
Any other questions? Representative Bergeron.
Thank you, Mr. Co-Chair, Mr. Chair. I'm just going to ask you a question because I know that you've been in a lot of education settings. But at this point, I had asked earlier the fact that I was a little bothered where it doesn't have anything here about a school or a school district. I guess I'm based on your opinion and what you're reading here, do you feel that's a critical step to actually have in here as far as the responsibility of a district, like, for example?
Sure. There may be other witnesses coming up who can speak directly from the school district point of view. When I send you the investigatory rules, I do believe that it speaks to there are provisions about notice when someone is under investigation, notice to the school that credential holder is under investigation. But off the top of my head, I wouldn't be able to give you a comprehensive view of all the rules that speak specifically to the school district's
I'm just asking
role.
To
Yeah.
follow
if
up,
you think that's a good idea
I
to actually have it.
Sure.
Is what I'm saying.
yeah, I think the more clear you make any law, the the better.
any other
We
questions?
just don't know what it is.
Seeing none?
Thank you.
Thank you. Diana Fenton, is that right?
Good morning. Thank you for having me. For the record, my name is Diana Fenton. I'm an attorney with the Department of Education. It is my hope today to answer some of the questions that were raised. So in the first instance, thank you for your consideration of this bill. I know it's been brought forward many times. It is very important to the Department of Education for this committee to consider our request to have subpoena power. We are doing so to be proactive in our investigations. The department does have limited authority and limited oversight of schools. But in RSA 21N9, and I'm happy to repeat that legal reference. I am an attorney and I can't stand when people just throw me legal references. So RSA 21N9, it sets forth the rulemaking authority. Now, the Department of Education is different from a lot of other state agencies in that the department itself does not have rulemaking authority. It is the Board of Education that has the rulemaking authority. So when you look at RSA 21N9, it says rulemaking for the Board of Education shall adopt rules in these various areas. And if you look at the very end of the statute, it is Roman numeral 2, double little c, 1. So 21N9, Roman numeral 2, double little c, 1.
CC.
I wish I had a whiteboard so I could write it up here, but I am not an educator, I'm an attorney, so please forgive me. But that is where House Education established the department, the establishment and enforcement of a code of ethics and code of conduct for licensed or certified educators. There was a question whether a licensed or certified educator could be in a private school, or we call them non-public school. The answer to that is yes, they could be. There was a question as to whether or not this applies to higher education. No, it does not. There is a question as to whether or not licensed or certified educators could be in charter schools. Yes, they could be. Charter schools are not required to have everyone be a licensed or certified educator, but they do have to have a certain number. So we could get a call from a charter school and the person could be an unlicensed educator. We could get a call from a charter school and the person could be a licensed educator. And within this rulemaking authority, again, not authority by the Department of Education, but the Board of Education, they set forth these professional codes shall include a statement of purpose and standards defining each of the 4 primary principles. And they set forth 4 principles. When the department, under the Board of Education Authority, undertook rulemaking, it became this document right here, the Code of Conduct. It is available on our website, but because this governs an individual's license, a teacher's license, we felt the need to put it into a booklet to make it accessible, to let the field know that this is your guiding document. I have these available if anyone would like them. We have them at the department. And in large part, and I'll just very briefly, the principles are, the first one is responsibility to the education profession and educational professionals. The second one is responsibility to students. The third is responsibility to the school community. And the fourth is responsible and ethical use of technology as it relates to students, schools, and other educational professionals. So this is the guiding document for licensed educators. As I mentioned, I'm not an educator. I'm an attorney, and similar to Representative Lynn, we have our own code of ethics and standards for attorneys. So all that being said, there was a question about the role of the Attorney General's office. The role of the Attorney General's office, they are the department's civil counsel. As Representative Lynn said, if the department gets sued, it is the Attorney General's office that will represent the state agency in a court of law. But the Attorney General's office defers to the state agency, whether it's the Department of Education or the Department of Labor or any other state agency, to do its own oversight on the field that they regulate. And so the Department of Education, or rather the Attorney General's office, would not come into the Department of Education and conduct one of these administrative hearings as it pertains to an individual's teaching credential. There was another question posed, and this has had a lot of traction over the past years as this bill has been discussed and worked on, as to whether or not the Attorney General's office can obtain a subpoena on behalf of another state agency, in this instance, the Department of Education. My understanding in speaking with the Attorney General's office is that they cannot. That is not a role that they would serve. I think to Representative Lynn's point, that would be a very onerous feature if they were to take that on for every state agency. And more to the point, if the agency doesn't have the authority in statute to seek a subpoena, it would probably be the wrong avenue for the agency to then ask another agency to obtain that document for them, which is why the department is here for House Bill 520. The question has also come up, can you give an instance in which this was necessary and which it was needed? So let me give you a quick overview in terms of how the department operates on these cases. This document that I've referenced, the Code of Conduct, if you were to look in our rules, you would find it under ED 510. ED 510 sets forth those 4 principles, and there's another principle, the duty to report. It sets out those principles, as I mentioned, that govern someone's teaching credential. It is the ED 511s that set forth the due process that governs when the department undertakes an investigation. And if an individual is placed under investigation, and that is a term of art under our ED 511s, that individual is noticed. They receive a letter from the department, sent certified mail, letting them know the department has opened an investigation. Here's the alleged violation. This is the principle we believe has been violated, and here's the factual basis. The superintendent of the employing school district is also notified. So to your point, the school is involved in that. The department really values its connections and its working relationships with the field. That includes credential holders, non-credential holders, school districts, and superintendents. So we did not want to place someone under investigation and not notify the superintendent, because it really is a working relationship. In large part, it is the school district that will undertake the investigation. This is the difference between employment and licensure. And so the school district typically will undertake the investigation. And we've seen that in some high-profile cases. Namely, there was a case in 2018, maybe early 2019, here in Concord, with an individual, a licensed educator, who was having sexual relationships with students, underage girls. It was the school district that hired an outside investigator, has nothing to do with the Department of Education, hired an outside investigator to come in and do a full investigation. Right? That was the school district's decision to hire an attorney to come in and do a full-blown investigation into that issue. Because it is the school district who makes that decision to hire someone to do an investigation, that investigation, that report, belongs to the school district. It doesn't belong to the Department of Education. It belongs to the school district. They paid for it. It is their product. And the case out of Concord is a great example. That educator committed sexual assault, is currently in prison in Massachusetts for having committed sexual assault on young girls. And there was another young victim involved as well. And yet the department could not simply just say to the Concord School District, can I have a copy of the report? It was very challenging to get a copy of that report. And in fact, I had to go to the attorney's office to view it, and I was not allowed to take it. I was not allowed to have a copy of it. So in terms of the department's ability to move forward in taking that particular educator to a hearing to obtain that educator's license, I would need, as part of due process and fundamental fairness, to provide that report to the credential holder. But I didn't have it. And so these are some of the things these are some of the practical realities that the department struggles with and deals with. And ultimately, in that instance, the credential holder turned his license over. He surrendered it, right? It worked out. And that is what the department has been successful at doing. But given the nature of what the department is working on, child safety, and I would encourage each of you to look at those 4 principles that are laid out in the Code of Conduct. And what you will see is a real emphasis on child safety. So I am not here to say, in the case of, State versus Jones, we were not able to get this document and this is why we need it. I am here to say, given the Code of Conduct, given the important work the department does in making sure that credential holders are appropriate around children, we would like this subpoena power as a tool in the toolbox. We don't need it as a first line of defense. Again, we really do value our relationship with the field and school districts, and we pride ourselves on a good working relationship with the school, because much to your point, Representative, the schools are a critical part of this. We cannot do these investigations without our partners. And the only instances in which the department typically takes the lead, if you will, and does not defer to the school district to do the initial investigation, is in cases that are older. So we have had instances, very small number of cases, but we have had instances in people coming forward and saying, back in the 90s, back in the early 2000s, I had a relationship with an educator. And that individual is still in the school district, and I'm concerned if that person's safe around children. And in that instance, it will typically be the Department of Education that will initiate and lead the investigation, and not the district. And we have had those cases. They typically have made the news. But as always, I have talked way too much, as lawyers tend to do. So I will open myself up to questions. I thank you for your time and your patience. I know this bill has kind of been the cat that we fed once and keeps coming back. So I appreciate your time and your patience. I'm happy to take any questions.
Thank you. It was excellent information, by the way, so I appreciate that.
Thank
Any
you.
questions?
Over there.
Representative Birch?
Thank you, Mr. Chair. Thank you, witness.
That's all right. I've been called worse.
Attorney
You should.
Fenton. And I appreciate your self-reflection at the end of your comments. I have a simple question that hopefully will just have a very short answer, and that is, can you quantify the number of cases that the DOE has not been able to effectively access information for each of the past 5 years?
We have been able to access the information that we need.
Thank you. That's all I asked.
Representative Perez?
Thank you. Thanks for taking my question. If a complaint is issued against a teacher that might affect their credentials, and that complaint goes to the principal and then to the SAU superintendent, is there anything mandating that they have to bring it to the Department of Education, because my concern is the incidences that might affect someone's credentialing that never make it to you.
Thank you for the question. Within the code of conduct, there is a duty to report. The superintendent has an obligation to report to the Department of Education if they believe that there is a violation of the code of conduct. Much to your point, however, I think there are a lot of instances in which a school district policy could be violated, but it does not affect the code of conduct. There are many, many policies, whether it's people showing up on time or classroom management or classroom organization, that might have an effect at the local school district level. It might very well be an employment issue, but it does not rise to the level of the code of conduct. Again, I would encourage all the members of this committee to look at the code of conduct, whether it's this booklet or the ED 510s on our website, as these are really focused on child safety issues.
Representative Morton.
Thank you, Chair, and thank you for your testimony, lawyer, attorney. So my sister's been a teacher for 35 years. Two of our grandparents were educators for more than 40 years. My grandfather was the superintendent of Merrimack Valley Schools, opened the school in 1967. So I'm very much pro-education. I just want to make sure everyone here understands that. I just have a question. Is this going to help streamline your procedures?
Thank you for the question, and I'm happy to hear you come from a family of educators. Very briefly, my mom was a special ed teacher here in New Hampshire, and when I called her and told her I was going to law school, she said, "But wait, I hate those people." And not much has changed since. So thank you to your family for all their work. The short answer is yes, it will help to streamline it, because the department has been successful in navigating these cases, but it hasn't always been the straightest line. And so this really is a tool in the toolbox. This is not meant to disrupt or affect our really good, strong working relationships with the field. We value those, and I cannot emphasize that enough. This is not to go pounding around and showing and flexing off our muscle. This is a tool for those horrible cases that we read about in the paper where the department says, we need to proceed and obtain this person's credential.
Representative Manos.
Thank you, Mr. Vice Chair, and thank you for taking my question, Attorney Fenton. Is it correct that you finalized a rulemaking recently? And if so, do any of the rules affect due process in the context of this bill that we're working on?
Thank you very much for the question. That was in my notes to address, and I failed to do so, so I appreciate you bringing that to my attention. As I mentioned, the ED 511s, which handle our due process piece of how we implement the code of conduct, those were recently redone, and they were finalized, I want to say June 17th of 2024. I know somewhere in mid-June, they were finalized and adopted. And again, you can find those on our website. We redid those because we realized that the rules that we had originally drafted were insufficient. We needed to strengthen them. We needed to make them better. And I'm humble enough to say I drafted the first version, realized that we needed to make it better, and I drafted the second version with our stakeholder partners. Nowhere in the ED 511s does it talk about subpoenas. It talks about the investigative process and notifying a credential holder that they are under investigation, notifying the superintendent of the employing school district that an individual is under investigation, and what the hearing looks like.
Representative Bergeron.
Trying to think of my question. It's okay. Thanks. I decided not to ask.
That's okay.
Representative Tripp.
Thank you,
be
Mr.
a
Chair.
good boy.
Thank you for taking my question. It appears that while you're able to get all the information that you want from the school districts, there may be some hesitancy. Would it be true to say that having subpoena power would make them much more compliant?
That's certainly the hope. In the first instance, we don't want to have to use that power. But the reality is, as I mentioned earlier, and you gave me a very nice short answer to give you, and being the lawyer I am, I'm going to just add to it. The reality is there are times where we need that subpoena power. And I cannot emphasize enough how much we value our working relationships. But yes, there have been times where we might need that tool in the toolbox. Thank you.
Representative Smith?
Thank you very much. If in fact this bill were to pass, would that mean that you would now have the authority to ask contractors with whom you have entered into a professional relationship to share with you detailed information about how they in fact acquire and expend public funds?
I don't.
As you well know, and everyone knows, you do not have to answer any question that we ask.
I actually didn't know that. You learn something new every day.
We'll just subpoena you.
Perfect. I've been there before, let me tell you. Thank you for the question. I was a little surprised by the question because that's not what this bill is intended for. This bill is intended for violations of the code of conduct. It is envisioned to handle investigations of educators who might have harmed a child. So I cannot envision a situation, and certainly it would fall outside of my purview. It would fall outside of the code of conduct. And I think the way the proposed bill is written, it is narrowly tailored to allow the department to effectuate the power that's already been given by this legislative body in 21N9. And much to Representative Lynn's point, it's frustrating at times as a state agency to have been given this authority to oversee licensing and make sure children are safe and not be given all the tools in which to do it. So I thank you for your consideration. I thank you for your time. I hope I've answered all the questions, and I see that I have not.
Representative Bergeron? I'm sorry, Morton. Opposite ends.
So real quick question, is a follow-up to the other question. If it's cutting, the procedural time, would it then be neutral, or do you think it would save the taxpayers money because it would be a cost-cutting savings measure as well because you're spending less time chasing after information?
I certainly hope that at the end of the day that it helps to save time, and if that helps to save taxpayer money, of course the agency wants to do that. Absolutely.
Representative Manos?
Thank you, Mr. Vice Chair, and thank you again for taking my question. I believe, and please correct me, that the Attorney General would have advised the Department of Education on its rulemaking, on its recent rulemaking. And I'm wondering why DOE would not have included subpoena power in their revised rules.
Thank you for the question. I wrote the ED 511s originally, as I mentioned, and I wrote the redraft that was adopted June of 2024. I'm sure the Attorney General's office might have been aware of that, but that is really a function of the state agency. I don't recall having in-depth conversations with the Attorney General's office about that rulemaking piece. Obviously, the other attorney who represents the Board of Education would be aware of that, but there was it wasn't an in-depth, well, let me think. The other attorney who represents the Department of Education and is connected with the Attorney General's office was aware of our rulemaking, was aware of ED 511. But to your point, why subpoena power wasn't put in there is because the department at this time does not have the authority. If we don't have the authority, we can't put it in our rulemaking. And if we put it in our rulemaking, it would have been flagged by OLS, and we wouldn't have been able to move forward with it.
Any other questions? Seeing none, thank you.
Wait,
You all set, Representative Bergeron? You?
I know I'm a little obsessed with this school district thing, but do you ever find that school districts actually have to contact the Department of Education if they have information before you do? As
Yes.
far as, okay, so that's one thing I was just kind of curious how that communication goes back and forth. So it could be driven from both then, okay.
Oh, absolutely. And in fact, usually the information comes from the school district.
Okay.
They're kind of the
Charter schools as well, because sometimes they have one school.
Oh, absolutely. I mean, we have good working relationships with the field, and I think
Field.
there are times where the field and the department can be at odds, but the reality is this: when it comes to child safety, everyone's on the same page. There is not a school district or a charter school or a superintendent or a principal who is not going to be up in arms when it's about child safety and making sure that educators are appropriate around kids. I have never met anyone in the field who says to me, oh, well, yeah, no big deal. Everyone is on the same page. And the department is so proud of those working relationships because we are all moving in the same direction on this issue. There might be other political issues that divide us, but not this. Not when it comes to child safety. And it is for that reason that we have strong partnerships.
Any other questions? Seeing none, thank you.
Thank you again for your time and consideration.
Thank you.
David Trumbull?
Thank you, Mr. Chairman and committee members. My name is David Trumbull. I'm from the town of Ware. I oppose this bill as it is written. I would agree with the last words of the last speaker. Everyone is on the same page when it comes to child safety. The only question with this bill is subpoenas. Who should issue them and what should be the legal standard? I believe the standard should be first, it should be done by, it should be done by the Attorney General. And two is the standard should be good cause. Let's look at how this is handled with other agencies in the state. Communications common carriers. If they need a subpoena, it goes to the Attorney General. That's RSA 76B. Charitable trusts goes to the Attorney General, RSA 724. Consumer Protection Act, RSA 358A, goes to the Attorney General. Department of Health and Human Services, 170E, goes to the Attorney General. In fact, 170E deals with child care, residential care, and child placing agencies, and it involves specifically disciplinary hearings, which is exactly the case you're looking at here today. And in that situation, they require the Department of Health and Human Services to go to the Attorney General, and they have to have good cause. That's the standard we use elsewhere in the statutes in New Hampshire, not the standard that you're getting in front of you today. As for what do other states do, I looked online, and the only thing I could find was a thorough report called the Administrative Subpoena Authority, written by the National District Attorneys Association, which reviewed laws in all 50 states. It's a 195-page report. There are no education commissioners who have independent subpoena power in the United States. So the standard, I believe, should be go to the Attorney General, and they should have to get good cause. And good cause is a legal phrase that has significance. If you look up the subpoena world, there's court cases that define good cause. There's law reviews that define good cause. It's more than the low bar that is in the bill that is written in front of you. I'd like to look at what the statute requires. First of all, it requires the hearings officer shall issue the subpoena if they meet two conditions. First, it's a possible violation of the code of conduct. And second, that it's reasonably likely to be relevant. Well, as was testified to earlier, the code of conduct has gone beyond credentialing. It's gone beyond child safety. It has now, unfortunately, gone into the culture wars. So what this bill would do is permit subpoenas on a whole broad range of issues, which was not the intent of the bill, nor is it the issue of child safety. As for reasonably likely to be relevant, anything would be reasonably likely to be relevant on any of these bills, whether or not a teacher is teaching What are they teaching in Black History Month? What are they teaching in Women's History Month? All of those could be suspect under some of the bills that have been put forward by this legislature in the last couple of years. So you have a very broad range of bills. Every lesson plan for every social studies teacher in the state could be subpoenaed because they could possibly be a violation of the code of conduct, and they certainly would be reasonably likely to be relevant. I'd like to just go back to a couple things Attorney Fenton said, 3 of them. First, the attorney said that the Attorney General defers to the agencies to do their own oversight. That's fine. The question is not, does the DOE do its own oversight? It's who issues the subpoena. The Attorney General would not come into the DOE and conduct a hearing. No, the question is not who conducts the hearing, it's who gets to do the subpoenas. The question then came up, well, can the Attorney General get a subpoena for an agency? And the Attorney General said no. Of course they're going to say no, because right now it's not in the statute. But I gave you 4 other statutes where they are specifically obligated to get the subpoena. So the answer could be, if you make it such, you could fix this statute, have the Attorney General do it. Lastly, was there an example of a hearing? Well, in the Concord case, again, the Attorney General subpoena would solve that. There is no example where the Attorney General subpoena won't solve it. So then the question is, why am I here today? Why do I want the Attorney General to do it rather than the Department of Education to do it? And what concerns me is the chilling effect of this bill. If teachers believe that there will be subpoenas issued as to whether or not they are teaching Black history in a certain way, and there will be subpoenas, they will avoid teaching it. And we will produce a generation of children who don't understand the history because teachers will just avoid teaching. The way you avoid having a negative impact on our state's education is just as simply to say, for this bill, send it over to the Attorney General. Have the Attorney General do it, have them do it with good cause, then you don't have this chilling effect on good education in our state. I think that covers everything I had to say. Thank you, sir.
Thank you. I have a question. So, of the agencies you spoke of when you first started testifying, how many of those agencies where the Attorney General files the subpoena have disciplinary hearings for licensees or certified employees, or is it the case that they are filing these subpoenas for violations of a certain statute that those agencies cover?
So like with the Department of Health and Human Services example, that was specifically for a disciplinary hearing. That's RSA 170E, Section 41. The department talks about disciplinary hearings, and they go to the Attorney General for good cause shown to subpoena witnesses and compel papers and records in any disciplinary hearing under that subdivision. So that's specific to disciplinary hearings. I didn't print out the other statutes. I looked at them this morning. I am pretty sure the charitable trust one is pretty broad, and again, it's trying to protect the public. So I'm sorry, I don't have those other 3 statutes in front of me.
Okay, so, but as far as somebody that works for the Department of Health and Human Services, is it specifically for their certifications or their licenses?
Oh, I understand what you're saying. Okay, no, okay, this is, I believe this would be for cases where there's a disciplinary hearing for somebody who works in child care, residential care, or child placing agencies. If there's a disciplinary hearing, it's a little different than a certification. But that goes back to the question of certification. If certification is simply a child safety issue, everybody agrees the hearing should be conducted. You should get your subpoena swiftly. Put it in the law. If it's a child safety issue, have the Attorney General do it. They can do it very quickly. They're lawyers. That's what they do for work. And there's a specific rule for lawyers. It's Rule 4.5 of the Code of Conduct for Lawyers. A lawyer shall not issue or obtain the issuance of a subpoena without good cause. So they know how to issue subpoenas. If there's a child safety issue, by all means, the Attorney General can get it quickly for you.
Okay. Any other questions? Representative Smith?
Thank you. Do you have a written copy of your testimony?
I do. I will
And if
I will
you
submit
could-
it.
If you don't have copy for everyone, could you at least give it to the clerk? And
I have one extra copy I'll give.
only one? Thank you.
Any other questions? Representative Birch?
Thank you for your testimony. Leaving aside the issue of the AG's office versus DOE running the show, just talking about the issue of code of conduct, would you find this a better bill if everywhere the term code of conduct was changed to language specifically limiting to credentialing? And eliminate the language of code of conduct?
Thank you for the question, Representative. I'm not sure. Could you just give me a little bit more to go on there? Like, what is it that you're trying to get at? I'm not sure I quite get
My
it.
question to you is, we've heard a lot of testimony from you and others that the code of conduct would allow investigations into an almost unlimited area of teaching. If code of conduct were removed from the statute and instead, or the bill, and instead the bill only allowed these subpoenas for questions of credential, would that solve the problem, or is credentialing itself open up the door too wide?
I understand better. Thank you for the question. I don't think you can separate it out because the code of conduct is what the teachers have to follow, and that's where the hearing is going to be. I think the distinction, rather than credentialing a code of conduct, is if it's a safety issue. That's where everybody immediately wants to get the Attorney General. The issue is really, as somebody said, other committees are studying bills and passing bills that have expanded what used to be understood as the code of conduct to being a broad thing, because they're looking for how do we enforce this and put some punitive action on the teacher. So they say, oh, okay, we'll just put in, you don't do this law, now you violated the code of conduct. So the code of conduct is now expanded to include how do you teach a certain lesson plan. So, but you can't, you could shrink the code of conduct down to a reasonable size, but I don't think you can take it out of this, because that's where the hearings come from, is what have been in the old days legitimate issues on code of conduct. Does that make sense?
Yeah.
Okay, thank you.
Any other questions? Representative Tripp?
Are you representing yourself or an organization?
I'm just here as a citizen, yeah.
Right, thank you.
Representative Horgan?
You're talking about expanding the code of conduct. Isn't there like an example of that actually right across the hall, about 12 feet from the door to this room, with a non-germane amendment to a bill, which actually ironically.
Is there relevance to this question?
So I just said, isn't that just one example of attempts to expand the code of conduct?
Yes, thank you, Representative Horgan. He's exactly right. That's the divisive concepts bill. There was a bill presented to repeal it, and then there was another amendment today. So that's exactly the issue here, is like, can you get a subpoena to make sure that people are teaching divisive concepts correctly, according to what you consider correctly? I think that's the concern here. It's not defending teachers. It's because teachers are just implements to educate our children. I'm concerned about the children who won't get an education if they're afraid to talk about issues, because they're afraid they're going to lose their license. And if you make subpoenas too broad, you reduce education.
Any other questions? Seeing none, thank you.
Thank you, sir.
Deborah House?
Okay, yes. Good morning. My name is Deborah Howes. I am president of the American Federation of Teachers New Hampshire. We represent about 3,500 educators and school staff across the state of New Hampshire, as well as college faculty and town employees. And we are here in opposition to HB 520, and it's not because we are not concerned about children being safe in our schools. We absolutely believe that is necessary and support the code of conduct. What we don't support is subpoena power for the Department of Education, even if it's done through hearing officers. We feel that this bill is a solution in search of a problem. As we have heard the past 2 times we've had hearings on this, and even again repeated today, the department is able to get the information it needs. We heard it very clearly stated from a previous testifier. They can get the information they need. Even in that horrible case she mentioned here in Concord, they got the information they needed. It had to go to the outside attorney that was hired by the school district, but they were able to get the information they needed, and they got the result they needed as well. So why do we need this bill? The department investigator testified that they are always able to get the information they need. We are keeping kids safe using the investigatory processes that are in place. This is an unnecessary bill. It would unbalance the current system we're using if we put this in place and put the weight more heavily on the investigatory side. You would not have the same power to subpoena as someone who is being accused of breaking the code of conduct at the same time. So there are timelines in place, and as someone who is suddenly accused of having broken the code of conduct, you would not have the same amount of time to gather information to defend yourself. And as Mr. Hawkins from NEA testified, there's only a limited amount of time to prepare your defense of that accusation before a hearing occurs. So you would be at a disadvantage before you're presented with what the results the department wants at that hearing. So that would be unfair to have that occur. My other point, besides the fact that this is a solution in search of a problem, is the safeguards in this bill, although they look nice on paper, having the hearing officer who works for the Department of Education apply the test of whether the subpoena is being sought in good faith and whether it's material. For a subpoena being asked for by his boss, I'm a labor leader. If the boss asks you to do something, at least in your mind, you're going to tend to agree with them, even if, you have all good intentions to view it impartially. It's going to be very hard to be impartial. And there's all sorts of room for there to be undue pressure. That's not a great standard. The previous speaker told you of other agencies, other departments that have the Attorney General issue subpoenas. Specifically, Health and Human Services has it for investigations in child care settings that are very similar to what you're talking about here, child safety. That would be a more appropriate place to go for a subpoena, because we do want to keep kids safe. And we also don't want to poison the relationship between our Department of Education and our school districts, who need to cooperate on these investigations, or between the Department of Education and our educators who are out there working with their children every day. We don't want there to be a climate of fear. We want everyone to be open and sharing information, because we do all have the same goal of keeping kids safe, making sure that they are learning and thriving. And I do have written testimony to share, but I do think that this bill is unnecessary, because we are getting that job done already with the tools that we have. This is an unnecessary tool. Thank you.
Any questions? Seeing none, thank you.
I apologize for not having stapled it. I thought I had double-sided it.
That's fine. Barrett, is it Christina? Christian? Christina?
Thank you, Mr. Chair. Good morning, members of the committee. My name is Barrett Christina. I am the Executive Director of the New Hampshire School Boards Association. To be clear, the School Boards Association is not taking a position on this bill, but we do want to identify a couple concerns that we have with the language itself. I'll make a couple points about the bill, and then I will make a couple broader policy points as well too. I'll try and be brief, recognizing we've been on this bill for a little bit more than an hour and a half. The first, I'm on page 1, lines 3 through 6, where it says that a subpoena may be issued against any person. NHSBA has concerns if that may be too broad. Does that just mean school district staff or the individual who is under investigation, or could it possibly be a subpoena issued against a student who perhaps was a witness to something, or perhaps even more concerning, the spouse or partner of the licensed educator who may or may not have relevant information to whatever investigation is going on. We have concerns that that is a little bit too broad. The second aspect that NHSBA has concerns with the bill, I'm on page 1 again, lines 24 and 25. The person to whom the subpoena is directed may file a motion to quash or modify the subpoena with the hearings officer. It's the hearings officer who's issuing the subpoena. I find it curious that the individual who would possibly quash the subpoena is also the individual who issued it. That may be common in other areas of law. I simply don't know. But it seems to be that there should be the appeal or the motion to quash should be provided to an independent third party rather than the person who is doing the investigation. And last, Representative Birch, you pointed this out, that while the license holder does have an opportunity to subpoena documents or whatnot during the adjudicatory stage, they don't have an opportunity to do so under this bill relative to the investigatory stage, which NHSBA believes would be the most important aspect of the timelines. Second, a broader aspect to the bill, when NHSBA was testifying on the bill 2 sessions ago and the proposed amendment 2 sessions ago, NHSBA suggested that guardrails and safeguards be put in place for students and student records. Unfortunately, House Bill 520 still does not contain those. If a subpoena is going to be issued for student records that are otherwise exempt from disclosure under state and federal law, we believe that there should be some guardrails put in the statute as to who at the department is going to have access to those, how long the department is going to retain those, at what point is the department going to destroy those student records. We also have concerns about a child being subpoenaed and then the parents having to go through the rigmarole of filing a motion to get it quashed before the hearings officer. The other aspect too, I guess, relative to a child being subpoenaed, there's no sort of enforcement mechanism in the statute. If I'm a parent and my child is subpoenaed and I read the bill and I'm perhaps given notice in the subpoena that I have 10 days to file an appeal, if I'm a parent and I don't show up and I don't bring my kid to testify, what's the department going to do about it? Am I facing some sort of criminal penalty as a parent because I don't want my child talking to an investigator at the Department of Education? The bill is not clear about that. So those are our concerns with the statute itself, or I'm sorry, the bill itself. A couple points to the larger, broader policy aspects. By way of background, I served on the committee that drafted the Code of Conduct back in 2018. The primary focus of that committee and that group, as Ms. Fenton repeatedly stated, was child safety, the health, safety, and welfare of children. And we reached great compromise through the teachers' unions, through people from higher education, school administrators, School Boards Association, and the Department of Education to come up with a really good document that everybody was happy with and everybody thought met the needs to keep children safe. It's important to remember that 2 sessions ago, when the first subpoena bill was brought forth to this committee, it had absolutely nothing to do with child safety. It had to do with what books were being taught in public schools. And as Mr. Hawkins spoke about during his testimony, we've had a plethora of bills last session and this session seeking to broaden impacts of the teacher code of conduct that have absolutely nothing to do with child safety and are far beyond what the original purpose and intent and goodwill created out of that committee was with the current code of conduct. It had to do with books, had nothing to do with child safety. So with that, I'll close my remarks. I'm happy to answer any questions. Thank you for taking my testimony.
Are there any questions? Representative Tura?
Yeah, thank you. Thanks for taking the question. It came up in the earlier testimony by other witnesses that other departments go through the Attorney General's office for subpoenas. And it seems in the list that you laid out here that many of those things could be handled by the discretion of the Attorney General if they were the entity that was being sought. Would it be your understanding that that would clear up some or many of the questions that you've raised?
Yeah, thank you for the question, Representative. I know that's been part of the conversation over the last couple of bills that we've had relative to this. I did hear one of the previous speakers suggest that. During his testimony, I kind of nodded to myself and thought that might be a reasonable alternative. Thank you.
Any other questions? Representative Smith?
Could you tell me if you are aware of any situation in which your organization would have advised your constituents not to cooperate with the Department of Education?
Thank you for the question, Representative. Just to clarify, our constituents are school boards and school board members. School boards are typically not involved in employee matters or employee investigations. Those are usually handled administratively through principals and superintendents. I'm trying to think if I've had occasion to speak to a school board member about that. No, nothing coming to mind. We've certainly, over the years, had inquiries from school superintendents where they're not certain if they should report something to the Department of Education, or they're not certain if it's a violation of the Code of Conduct. Our advice is call the commissioner or call Ms. Fenton and flush it out that way. I mean, it's not my job as an attorney to tell you not to report something. If you report something and the department doesn't need to go any further, there's no harm, no foul. If you don't report, there are significant consequences. Thank you.
Any other questions? Seeing none, thank you.
Thank you.
That's the last card I have for House Bill 520. Is there anyone else that wants to speak on it? Seeing none, I'm going to close the hearing on House Bill 520. And I'm going to open up the hearing on House Bill 188 relative to contempt of the general court. And I recognize Representative Lynn to introduce the bill.
Thank you, Mr. Chair and members of the committee. As those of you who were here in past in the past legislative session may remember, there was a rather unfortunate incident that developed, not in this committee, fortunately, but involving the issuance or the attempted issuance of a subpoena to witnesses coming before the legislature. That resulted in quite a kerfuffle, and it was really, I think, a very unfortunate situation. But one of the things that developed as a result of that was the question of, was a whole question of issuing subpoenas. Can that be done? And there is in the existing rule, there is a provision that talks about that. But there was a question of then what, is there any law on this? Is there any statute? Is there any law of what's the consequence if a subpoena is issued and if it's not complied with and that kind of thing? So there was a group of people who got together, and in particular the speaker and the deputy speaker asked me if I would take a stab at drafting legislation to cover that. And I undertook some research, and 188 is sort of the product of that effort, and it basically establishes both a civil and a criminal penalty for someone who is subpoenaed. And there are, in the rule, it's there are very limited circumstances, including which requires the approval of the whole House and requires the concurrence of the speaker in the current rule, as I recall it, before a subpoena can be issued. This statute doesn't deal with the issuing of the subpoenas as such, but it deals with what happens if somebody fails to comply. What can the legislature do to compel compliance? And during the course of my research on this, what I discovered is that even without, is that there is no law in New Hampshire on this. There are a number of other of states that do have laws on this, and in particular, I took the sort of generally the format for this from a federal statute dealing with contempt of Congress. This is not exactly the same as that statute, but it does incorporate a number of elements of it. At any rate, one of the things that I discovered in the course of that research is that there is some authority. There's no New Hampshire authority on this, and I'm not really sure how many other states have authority on it, but there is some at the federal level. There is some authority that basically says that Congress, that a legislative body has the inherent authority to both compel people to appear before it via subpoena, and if they fail to do that, to punish them. So, for example, there, you know, in many in the long past, there were a number of instances, and the research that I recall, the last time it happened at the federal level was about, I think, in 1914, where the Congress or a committee of one house or the other, with the approval of the Congress, actually sent the sergeant at arms out to arrest somebody who had failed to comply with an order to appear, you know, so that inherent authority of the legislature arguably would allow us to do that too. I don't think that we've ever done it. I'm not suggesting that we ever would want to consider doing it, but apparently there is some, at least arguably, there's some inherent authority to do that. But one of the things that prompted this bill was, you know, a number of people said, well, you know, wait a minute. I mean, if we ever actually got to that point, should we just sort of leave it up to, like, you know, we'll decide whether we want to have the senator send the sergeant at arms out to arrest somebody, and then once they arrest them, what do we do? Do they bring them to court? What happens? So the question is, without this legislation, we can just leave it and play it by ear, and, you know, hope that if it in the unfortunate situation that ever happened, we'll play it by ear what we do, and presumably the courts would be playing, and at least in New Hampshire, would be playing it by ear in terms of what they do. Or does it make sense to have a procedure specifying what happens? And that's what this bill attempts to do. As you'll see by reading it, it has a whole lot of conditions that have to exist before either the criminal penalty or the civil enforcement procedure can arise. It requires, you know, that the House or the Senate, or if it's joint, both bodies determine that the person is in contempt, that they had no basis for failing to comply, and there would have to be a vote by the entire bodies to do that, and then it would go to the courts, and the courts again would have an opportunity to review that judgment and determine whether there was a valid basis for failing to comply. The criminal penalty that is provided is, you know, it's a misdemeanor. It's not particularly significant penalty, and the civil penalty provides that there could be a finding of civil contempt and an order that at the most extreme in the civil context would be an order that the person be incarcerated until they comply. That's the typical civil contempt remedy. So with that, hopefully if this became the law, it would never come into play, because we'd never get to that stage. But I suppose it is better to have it there than not have it there. That would be my sense on it. I'm happy to answer any questions.
Are there any questions? Representative Burke.
Thank you, Mr. Chair, and thank you for your explanation. I personally tend to agree about the inherent powers, but we'll put that aside. my question to you is the operation of on the criminal offense only. Understanding the civil remedies are fairly traditional. So in line 4, we have what I'll call the wandering concept of knowingly. And folks understand that knowingly is a certain state of mind. And but when we get down to line 8, it's simply, you're wrong. You didn't have a good reason, whether it's knowingly or not, and then you can be found guilty of a misdemeanor. So my first question is has knowingly dropped out of the consideration in this in this section?
I'm not, you know what, I'm not sure I understand. It certainly was, I think the knowingly, my intention was that it applied to, you have to act knowingly, but I'm not quite sure I understand where you're saying it. You have a question about whether it would apply.
Well, in line 8 to 9, or who having appeared refuses to answer any question or produce any books. My question is that a knowing refusal at that time with an explanation?
Sure. I mean, I think yes, I think knowingly does apply. I mean, if it's hard, I think certainly the knowingly would, I would intended that to apply there, but I guess what I would say is it's hard to imagine how somebody refusing would not be that you don't know you're refusing. I mean, particularly where it says without just cause. So but if somebody asks you a question and you refuse to answer, it's hard to, I mean, I certainly did intend it to be no. I suppose somebody could accidentally refuse, but that would be,
And what are the consequences of the guilty of a misdemeanor? Is there punishment to be followed thereafter? Are there limits on that punishment?
Well, it would be a misdemeanor. You'll notice it doesn't say a Class A misdemeanor, so I suppose it could be. I think it would be subject to the other law, which would say since this presumably is not a violent offense. So unless the prosecutor gave notice that they intended it to be treated as a Class A misdemeanor, it would be a Class B misdemeanor.
And the consequences of
follow-up?
Yeah, follow-up. And the consequences, other than on your record, of a Class B misdemeanor would be limited to what?
Class B misdemeanor, there's no jail time. I think the fine I think it's $1,200 is the maximum fine, unless it may have changed since I was more intimately familiar with that. But there's no jail time. I think it's $1,200 maximum fine.
Thank you.
Representative Tura?
Yeah, thank you. And thanks for the question, taking the question. I guess I'm wondering, from what I understood from the incident last year and from your opening, committees by themselves in New Hampshire can't issue subpoenas without going through the general court. That's what I mean, first of all, I never thought about until this whole incident issued, the idea of issuing subpoenas was never something that was on my radar screen. Right.
I think that you are right, but apparently there was a not insubstantial group of people who didn't share that view of, so
can I do follow-up? Yeah. So, and my understanding is that you're not trying to to clarify that in any way. This is basically what happens if someone doesn't.
Exactly. This is this doesn't, you'll notice there's no reference to subpoena anywhere in here. It's it's about.
It is referenced online.
Well, I'm sorry. In terms of when a subpoena should be issued or anything like that.
Right.
It's what happens if you don't, if it is issued and you don't comply.
So one more follow-up. Sorry. So I guess what I'm wondering is the way it's worded, like on line 5, it says, comply with a subpoena duly issued and served by either house of the general court. I'm wondering, all the stuff after it seems to imply that committees do have subpoena power, sort of by reference under this larger statement. I'm wondering, does that all need to be there? Because it seems to confuse the issue rather than just saying a subpoena duly issued by either house of the general court. Is that clear what I'm asking?
No, it is, but you know what? I took this part of the language, I did take from the federal statute. I think it's 2 USC something. And I think that the language, you're right, it is long. There's a lot of different clauses, a joint committee, and that I took out of the federal statute because I think it's designed to kind of capture a number of situations. In other words, a committee of the House or a committee of the Senate or a joint committee, if there were such a committee. But I think all of the critical language is subpoena duly issued. So that I think which really I think applies to everything that follows, so that whether the subpoena was duly issued was it issued in accordance with the rules of either the House or the Senate, or if it was a joint committee, presumably the rules of both bodies.
Yeah, to just clarifying, I that's what I was wondering, is this I don't know whether there is something that spells out what's a duly issued subpoena by the general court or either body, but it feels like adding all that extra language seems to imply a definition of all that, which I wasn't sure was consistent with the rule that may or may not exist for doing that.
I don't think that it does do that. I think it just basically all the language after duly issued is basically designed to cover, what the subpoena, if it was duly issued, might cover, like a subpoena for testimony or subpoena for books or documents or records, and who would be issuing it would be, in what proceeding was it issued in connection with a House committee, a Senate committee, a joint committee, maybe the full body of either one. I suppose it could cover any of those. But in terms of whether, the prerequisite, that is a duly issued subpoena, that would depend on the rules. And I do agree with you that right now, at least the rules of the House are, let me put it, they could be clearer than they are. That's for sure.
Any other questions? Representative Manos?
Thank you, Mr. Vice Chair, and thank you for taking my question. I wanted to discuss lines 13 and 14 and also line 26. And I wasn't clear on, you have failure to comply as being a misdemeanor. Excuse me. But then a prosecution would be in the Superior Court for Merrimack County.
Right.
And I was confused about why a misdemeanor would specifically go to the Superior Court rather than the Circuit Court. And then I also wanted to ask about line 26 and the potential conflict between a criminal prosecution being in the Circuit Court versus civil being in the Superior Court.
So basically what I intended to do with both of these is to limit the place where the prosecution could be brought and limit the prosecutor. So that in the criminal case, that was an intentional decision to make, even though it's a misdemeanor, to make it have to be prosecuted in the Superior Court, because this would be such a prosecution would be a very unusual procedure. It seems to me it would be better to have such a prosecution to be in the Superior Court, since it would have to, since it would involve the legislature, which sits in Concord, Merrimack County. Limiting it to Merrimack County seemed to me to be another way to circumscribe this, and also requiring that it not be that the prosecution, if it's going to be undertaken, would be undertaken by the Attorney General's office rather than a county attorney. All of those things are designed to kind of to recognize that this would be in some sense, an extraordinary prosecution, and for those reasons should be limited to where it's brought, who can bring it, and what court it's in.
Then would it not make more sense for violation to be a felony rather than a misdemeanor?
Well, I mean, I guess I would say, I would say no. I would say that you don't want to. I mean, it seems to me that the kind of situation we're talking about here of somebody being held in contempt of the of the general court, very, very rare, if ever, we're going to see such a situation. And if there was one, my inclination would be that the prospect of being convicted of a misdemeanor, which arguably could turn into a Class A misdemeanor where there would be up to a year in jail, that would be enough deterrence to get the job done. So I would be opposed to making it anything more harsh than that.
Representative Smith?
Thank you very much. Could you tell me how this relates to Rule 28 of the New Hampshire House of Representatives rules?
I think the way it relates is this. Rule 28 has a procedure. I mean, I assume I don't have the rules in front of me, but I assume 28 is the one that talks about subpoenas. Am I correct in that?
Yes, it's relevant.
Right. No. So I think what the way it relates is this statute says what happens if the subpoena issued pursuant to that rule is served and somebody doesn't comply with the subpoena. Right now, the rule doesn't say anything about it. That says, it talks about when a subpoena can be issued, and it doesn't say that's where it ends. So a subpoena is issued under the rule. Okay, now what happens?
Could I have one follow-up?
Yep.
Thank you very much. I ask because of the thoughtful question that our colleague Representative Turr raised. Am I incorrect in saying that the House rules say that a subpoena can be issued only by a vote of the full House? And that would be Act 1, so to speak, in this drama. And then Act 2 is if there was a failure to comply. But Act 1 is already in our House rules. Is that not true?
Oh, no, I think that's right. I think, as I said, I think I would read Rule 28 the same way that you and Representative Turr read Rule 28. Some people apparently had a very different view of how Rule 28 should be read. But I agree with you. I think you're right. But I think what that whole incident raised, I suppose maybe there's a ray of sunlight in every in every cloudy situation. Okay? So let's assume that we actually get to the position of issuing a subpoena and somebody doesn't comply. Then what happens? And that's what this is designed to
Could
deal
I
with.
be in one more short one? You could say no,
No, you can certainly
You
do
could
that.
say no to me. I think Mr. Chair, that I resist always references to people by party and making considerations by party. But I must ask you, is there a reason why there is one senator listed as a sponsor, but there are no Democrats in the House or the Senate? Is this perceived to be something that is of concern only to Republicans in the House?
Well, I mean, it's certainly the generation of this, and I talked about the speaker and the deputy speaker and myself. I mean, the generation of this was certainly something that was talked about in my caucus, and my caucus was the one that proposed this. And so that was, you know,
Thank you.
I
That's
just
fine. You don't
no,
have to
I but I think it's a legitimate question. I frankly did not, and I think that I assume that this is true of the speaker, and the deputy speaker didn't think to ask members of the other party. And
I rest my case. Thank you.
yeah.
Any other questions, Representative Birch?
Just a quick question of clarification, based on your response to Representative Manos. The prosecution by the Department of Justice, would that be discretionary with the Department of Justice to bring it, or is that mandatory because the House has taken a certain action?
I think there's nothing, no language. I don't think that the legislature could compel the executive branch to bring a prosecution. We might be really upset if they didn't. Maybe that would have some effect on their budget, but I don't think that we could. I don't think that we could compel the executive branch to bring a prosecution.
Thank you. I just wanted to make sure that was part of the record.
Yeah, I mean, that's another reason to limit this to the Department of Justice, because it makes sure that, it's not going to be brought by a county attorney. If it's going to be brought at all, it's going to be the Department of Justice.
Thank you.
Any other questions? Seeing none, thank you.
Is there anybody else that's testifying on
Nobody.
this? Oh, okay.
I have no other cards on this.
Okay, good.
Is there anyone else here that wants to speak on House Bill 188? Seeing none, I'm going to close the hearing on House Bill 188. And we're going to open up the hearing on House Bill 195 relative to the expectation of privacy and the collection and use of personal information. And I recognize Representative Lynn to introduce that bill.
Thank you. Let me go check. I'll be back.
Representative Bergeron, could you turn off your microphone if you're not speaking? Great, thank you.
I heard you breathing.
It affects the other.
I mean, he's here, but he's just not.
In and out.
Right. All right. Sorry. Thank you, Mr. Chair, members of the committee. There are two bills that we've listed for hearing that are deal with privacy. 195 is last year's House Bill 314, which passed the House, and somebody's going to have to correct me. Representative Smith, you may correct me if I'm wrong. I believe it died in the Senate. That's my recollection, is that 314 died in the Senate. So my recollection, again, I stand to be corrected by those of you who were here last year, is that 195 is the same bill as 314 last year, and that it passed this committee and passed in the House on a bipartisan basis. And what it was and still is intended to do is to be something of a supplement to Senate Bill 255, which was the broader privacy bill that was passed 2 years ago. And the way that this bill differs from 255 is, first of all, this is a disclosure bill. It deals only with the disclosing of information. It doesn't, unlike 255, it doesn't have really much to do with the acquisition of information. It's only the disclosure of information. And it basically says that for a limited category of organizations referred to as third-party providers of information and services. And the important thing to understand is that in the definition of third-party provider of information and services, that is a narrower definition than the definition of the various businesses that would be covered by 255. It is limited to organizations that collect information about a person in connection with providing the following kinds of services: cellular and landline telephone, electric, water, other utilities, internet service providers, cable television, streaming services, social media and service providers, banks and financial institutions, and insurance companies and credit card companies. It's designed basically to cover those kind of institutions rather than more broadly all businesses, which is, or at least all businesses of a certain size, which is what 255 cover. And it basically is designed to say, if you are one of those covered institutions, then you can't disclose personal information as defined in the statute unless you have the consent, and the consent has to be affirmative consent. 255 basically has sort of an opt-out, for lack of a better term, an opt-out feature that you can opt out of having personal information disclosed. But this bill provides more protection in that it requires that you affirmatively agree, and that there's requirements that it has to be, this can't be some getting your affirmative agreement in some sort of nefarious way where you're not likely to think about it. It's got to be an affirmative. A communication is sent to you. Do you consent to doing this? And you agree affirmatively to do that. So that's one way. And then the bill has a number of other instances in which some covered businesses can disclose information can disclose information that is personal information in certain circumstances. And I want to, in the interest of being brief, I know that there are other people that will be testifying. One of the things that someone expressed, one of the sort of a business, an industry representative expressed a concern to me about was, does the bill as worded allow one of the covered entities to disclose information if they have reason to believe that there's been some nefarious activity going on? And the person that talked to me was sort of said that they were concerned that the bill did not allow that. I think that that's not correct. I think if you look on the top of page 2 in Roman numeral 507I2 1B, it says that the third-party provider of information can disclose information if they have reason to believe that such disclosure is necessary to prevent, detect, protect against, or respond to past, present, or expected criminal or fraudulent conduct, identity theft, harassment, or deceptive or malicious activity. So I think it is designed to say that that can happen. You'll notice that the bill also has specific provisions dealing with the disclosure of personal information at the request of governmental entities. And it allows that to be done, but it contains requirements that have to be satisfied in order for that to be done. And as I said, this was something that I think was pretty carefully thought out by this committee last year. It was approved on a bipartisan basis and was approved by the House. And I think it is a very reasonable bill, and I hope you'll support it. And I'm happy to answer any questions.
Any questions? Seeing none, thank you. Neil Kirk?
I just checked.
Okay, we'll hold his card then. Okay. I'll hold his card. Kirsten Schultz.
Good morning, Mr. Chairman and members of the committee. My name is Kirsten Schultz. I'm an attorney based in Manchester with Nixon Peabody, and I'm here on behalf of State Farm, which is one of the leading writers of home and auto insurance here in New Hampshire. I'm here to note our concerns with HB 195 as drafted. I didn't expect to go first. I just have some high-level concerns that I'll briefly tell you about, and then I expect that there are others here who may voice similar concerns. But we are primarily concerned with the bill because it adds an unworkable overlay to the already complex landscape of privacy compliance for insurance companies. SB 255, or now enacted as RSA 507H, which went into effect earlier this year, includes the exemptions relevant to State Farm as an insurer. But this bill fails to incorporate those same exemptions. And the bill appears to cause some conflicts with the existing law and exemptions, particularly with respect to what we might define as personal information or non-public personal information or personally identifying information. The bill is, it could be drafted better and more clearly. We think that obviously it fails to take into account those exemptions that are in RSA 507H. We would be happy to work with the committee to try to redraft some of the language if that's needed. And we would respectfully note that the structure of this bill with the opt-in framework is different from what one tends to see in other run-of-the-mill privacy bills here and elsewhere. The opt-in consent mechanism for the disclosure of personal information is problematic for us for a number of reasons. We would certainly prefer to have an opt-out mechanism because that would, from our perspective, lower compliance costs while still empowering individuals with decision-making authority over how their data is utilized. And as Chairman Lynn noted, the RSA 507H4 does contain that opt-out framework rather than an opt-in. Under the bill as drafted, the process for seeking consent is separate. It has to be separate from any other communication sent to the individual by the third-party provider of information and services, and that creates a pretty big additional step for State Farm anyway. That would require development of new forms and notices to be implemented, and that could also be very costly. In proposed section 507 I3, Roman 3, disclosure of personal information to government entities, that requires that a provider must contemporaneously with such a disclosure to a governmental entity provide notice that it has made that disclosure to the individual to whom the information pertains. And again, contemporaneous disclosure is not very practicable for a number of reasons, and we would propose considering possibly increasing that time period or defining the amount of allowable time to disclose to the individual, for example, 30 to 45 business days, just as a suggestion. The bill does also put limitations on sharing data, obviously. You can't share data with service providers, vendors, affiliates, and the problematic part of that from a practical perspective is that State Farm, as an insurance company, often discloses phone numbers to service providers, even to other insurers, in the course of claim handling. That goes on frequently. And lastly, I would say just the enforcement mechanism that is included in the bill as drafted. Enforcement's conducted by the AG's office, meaning that for State Farm, it would really add a whole nother regulator, another agency. And it's also concerning that there is no opportunity to cure an alleged violation built into this bill before the AGO commences an enforcement action. So those are our high-level thoughts on why we think the bill is problematic as drafted, and we would oppose it. happy to respond to questions if necessary.
Are there any questions? Seeing none, thank you.
Thank you very much.
Oh,
I'm
Representative
sorry.
Paterno?
Do you have any written testimony for the committee?
I have my notes. I'm happy to submit my notes later.
That
if
would
you'd
be
like
great.
Me to.
Thank you.
Okay, thank you.
Lieutenant Steve, is it Macaulay? Macaulay? Macaulay?
Good morning, Mr. Chair and members of the committee. My name is Lieutenant Steve McCauley. I'm with the New Hampshire State Police and representing the New Hampshire State Police on House Bill 195. We are taking a neutral stance, and this is really just educational, just some of the two concerns that we see with the bill as is. The first one I wanted to address was on page 3, line 1, where it states that shall not require production of the information sooner than 10 days from the date the request or demand is made. And then within 5 days, receiving such a request or demand, the provider shall notify the individual who the information pertains to. The concern we see with this is while we're in the midst of investigating a crime, and with myself, I'm the lieutenant of the major crime unit. In investigating these egregious crimes, we're often submitting subpoenas, multiple subpoenas, looking for different records. This one addresses some about cell phones, and that sort of type of records. When we're issuing these subpoenas, oftentimes we need this information back very quickly to be able to continue our investigation on, to possibly make an arrest or increase PC to get an arrest warrant, or to be able to locate a person who is wanted for a crime. Oftentimes it's a very violent crime. If the production is not, does not have to be within 10 days, that could delay us getting this information to be able to enforce these crimes, such as homicide or whatever crime it may be that this falls under, as well as be able to gain more probable cause towards an arrest warrant. So this could cause us some sort of delay in getting this information. And then the notification down on line 15 or 14, it starts, it talks about contemporaneously notifying the customer that this request has been made. This causes a concern for us as well. Under these circumstances, the 507 I3, IC, primarily ID and IE, which would be more of an exigent circumstance for us. Oftentimes, these requests to these providers under the exigent circumstances are requested prior to the primary investigative team arriving to these locations. It may be requested from, say, a 911 operator like this outlines, or the local police department may have a phone number and they may request active pinks on someone that, say, somebody just kidnapped 2 children and they're on the run. They may request these pings and this information through this, and then this states that contemporaneously they need to notify the provider. As you can see, this would cause an issue if we're trying to track somebody that has committed a violent crime or committed any crime that we're able to enforce this type of activity on, but then they're notified that we're currently looking for them, and they're notified that we're looking at their cell phone location such an attempt to locate them. I would imagine, so this would give them opportunity to then further hide or shut off their phones, or make it much more difficult for us to find them, and then the possibility of them committing whatever their final plan was or act is, and maybe speed up that timeline. Those are our two concerns, primarily with House Bill 195 as it reads.
Representative Smith?
Thank you for being here. I'm a little surprised. I'm glad to see you. Always glad to have people come. But as I read the bill, your issues that you raised are very, very important, and you're exempt under this bill from any of the restrictions that you talked about. I see it in, well, let's see, the first place I see it is well, if you just start on page 2, line 18, and you go on through all of that, and then you also specifically on page 3, starting with line 9, all of that would, I think, answer your quite legitimate concerns that your situation is unusual and requires immediate response. Am I missing something here?
As we read it, if I do go on to page 3, line 9, like you state, it says when a government entity seeks disclosure of personal information from a provider of information and services pursuant to RSA 507 I3, 1C, 1D, or 1E, the provider shall contemporaneously with such disclosure provide notice that it has made the disclosure. So I guess maybe that's our confusion, but I feel like that states that even if we make it under the exigent circumstance or under the circumstances in 1D or 1E, it's still going to notify, or it's saying that it still shall contemporaneously notify the provider.
And then did you go on to read the rest? I don't blame you if you don't. This stuff gets very boring.
Are you talking about I?
Well, it goes on and it
So
you go. I mean, it seems to me that
and I'm sorry,
if
maybe
if it needs to be clarified, then I'm certainly glad that you brought that to our attention. But I think a careful reading would show that this acknowledges that there are circumstances, particularly those in which you would find yourself, where you have to be able to move quickly, and this would permit that.
Thank you, Representative Smith. So I did not see an exemption for notification. What I do read is that the government entity seeking the information demands that such notice not be provided and furnishes the provider with basis of its authority to make such a demand. So it would make us, we would have to make that demand. And our worry is that if it is the 911 operator or making that demand in a split second notice, they may, I guess, not make the demand that we not notify. So I maybe we're confusing it, or I'm misunderstanding that, but that's how it reads, I guess,
well,
to us.
If I could just if I could respond, if it's all right. Yep. I thank you for bringing our attention. I think we'll take some time to go over it carefully. And one thing that you might have brought to our attention is the need to make sure that the 911 people have appropriate training in terms of how they react. But whatever, I mean, we will not ignore your suggestion. I think we think that we're on the case, let's put it that way, and we don't have to take any more time now. But so thank you very much for coming and taking your time to tell us about this.
Any other questions from anyone? Seeing none, thank you.
Thank you, Committee.
Is it, Reagan Hale? Am I getting that right? Ryan? A lot of doctors. I can't read. Wait, hold on.
Still morning. Good morning. Chairman Lynn, honorable members of the House Judiciary Committee, thank you for the opportunity to provide testimony in opposition to House Bill 195 relative to the expectation of privacy and the collection and use of personal information. For the record, my name is Ryan Hale, and I'm Vice President Government Relations for the New Hampshire Bankers Association. The New Hampshire Bankers Association represents 40 member banks across the state, employing around 6,000 individuals. We do appreciate the sponsor's interest in protecting personal information. Banks are committed to protecting our customer data, and we already have to comply with strict federal privacy laws, including Graham-Leach-Bliley Act, which requires banks to safeguard customer data with strict security measures, the Right to Financial Privacy Act, which requires us to protect customer financial data from government access without legal authority, Fair Credit Reporting Act, the Bank Secrecy Act, which helps prevent fraud and identity theft, as well as federal cybersecurity standards, which mandate strong IT security and risk management. Along with that, banks are routinely examined for compliance with these federal standards, and failure to adhere could result in fines up to $100,000, personal liability for executives, and enforcement action by their regulator. As you heard, the legislature just last year recognized the importance of protecting consumer data with the passage of Senate Bill 255, was signed into law last year, and I believe went into effect January 1st of this year. Our concern with passage of 195 is this would disrupt the uniformity that SB 255 set out to achieve. As you may know, Senate Bill 255 was modeled after similar laws passed in several other states, which is vitally important, lacking any congressional action on this front. Some of the concerns we have, we feel that this could impact fraud prevention. Fraud is on the rise with financial fraud is on the rise with our bank customers. We feel that it does limit the use of biometric data. That is a key tool in some cases when determining customer is who they say they are. We also feel that this may delay fraud investigations by creating new restrictions. And just to sum up, the key risks that we see, there could be regulatory conflicts and compliance burdens. We could see increased compliance costs. There is legal and financial liability with penalties up to $1,000 per violation, operational challenges with data requests and restrictions, and standard banking standard banking practice, specifically potentially hampering fraud prevention and identity verification. So in closing, we would, like others, urge the committee to vote inexpedient to legislate on House Bill 195. Thank you for your time. I'm happy to answer any questions.
Are there any questions? Seeing none, thank you.
Thank you.
Christopher Gilrain?
Thank you very much, Mr. Chair, members of the committee. Chris Gilrain here representing TechNet. We are an industry association representing about 100 companies throughout the innovation ecosystem. Here to raise our concerns with H195, not because we oppose data privacy legislation. In fact, we were here 2 years ago in support of S255, which is now the law of the land as of January. So I do think it makes sense for us to take a step back and recognize what you all did last session and what is the state law as of in effect as of this January. New Hampshire consumers have the right to access, correct, delete, and export their personal data that is held by companies that they interact with. They can further opt out of the sale of that data or the processing of that data for purposes of targeted advertising or digital profiling. The companies that collect this data need to limit what they collect in the first place and disclose the uses and the types of parties that they share that information with. They must maintain that data in a safe and secure manner, and they cannot process sensitive data without opt-in consumer consent. This is what is in statute today. Here in New Hampshire and in nearly 20 other states, including our New England neighbors in Connecticut and Rhode Island. H195 would be a significant change to the companies that are currently complying with this law. The bill, for example, does not delineate between controllers and processors of data, which is a hallmark of every other comprehensive data privacy law. This establishes different responsibilities for entities that actually interact with customers versus those that operate in the background as service providers. It further does not distinguish between sensitive data and the kind of basic units of information that get passed as a matter of course in most internet transactions. The main concern here is consent fatigue. Folks get so many consent requests to opt in that they simply start clicking through them. The importance of opt-in consent for sensitive data is that it gives you pause. You consider whether sharing this specific information is necessary or in your best interest. When it comes up with virtually every interaction you have with a website, it just becomes rote, and that's what we worry about. For example, so my favorite campground, Moose Brook State Park in Gorham. I go to NewHampshireStateParks.gov. As is typical with any website, the ISP discloses my IP address. I get my first pop-up, do you consent to this? Then I click on the Moose Brook link. That takes me to ReserveAmerica.com, which is the third party that operates all of the reservations for all of New Hampshire state parks. I get another pop-up because I'm going to another site. I'm going to hit several more roadblocks on my way to actually processing that transaction and getting the campsite that I want. Now, there are comprehensive data privacy laws in Rhode Island and Connecticut, and there are state parks in Rhode Island and Connecticut. Not necessarily as good, but you know, they exist. And I could complete that entire transaction seamlessly. I could further tell ReserveAmerican.com not to sell that information that I used to process that transaction. And if, for whatever reason, that site wants to ask me about my racial information or needs my exact geolocation data to, for whatever reason, to process that transaction, they have to ask me for that. And that is the opt-in process for the sensitive data. That's the case in Rhode Island, that's the case in Connecticut, and that is the case in New Hampshire today as it stands. With that, we ask that the committee find this inexpedient to legislate and allow the relatively new comprehensive data privacy law here in New Hampshire to play out.
Representative Perez?
Thank you. Thanks for taking my question. So do you view this as a solution looking for a problem?
I would say that the existing law S255, which you passed, was the solution to the problems that I believe this is intended to address.
Thank you.
Any other questions? Seeing none, thank you.
Thank you.
Neil Kirk?
Good morning, Mr. Chairman, and good morning to committee members. For the record, my name is Neil Kirk. I live in Ware, and I'm representing myself today. I'm here in support of House Bill 195. This bill protects an individual's personal data, name, birth date, social security number, biometric identifiers, etc., from government or business intrusion when the personal information is given by the individual to a provider of goods and services, for services and information, such as telephone companies. When you sign up with a telephone company, you give them all sorts of information. They use it, but the reason you're signing up is not to give them the information, but to get the telephone service. Same thing with internet service providers, streaming companies, social media providers, credit card companies, etc. The reason why this bill is necessary is that the legal situation is unclear today. As far as the United States is concerned, Supreme Court decisions involving the Fourth Amendment search and seizure prohibitions, under those decisions, there is no expectation of privacy and personal information given to the providers of these services. That means that today, a provider of information and services can do whatever it wants with the information, the personal information that you've given it, with or without a subpoena, unless a law dictates otherwise. Now, there is one federal law, for example, for banks, the Right to Privacy Act in 2000, which deals to some extent with this. In New Hampshire, the situation is a little different, but there is no statutory guidance. In New Hampshire, our Supreme Court, perhaps even under the guidance of one former Supreme Court justice, I don't know if he was there in 2003 or not, but in 2003, in the case of State versus Goss, an expectation of privacy was created in garbage. This is New Hampshire, in garbage, which was placed in black plastic bags left within 3 feet of the street for collection. So police couldn't open the bag and use anything in it without getting a warrant. In 2005, in the State versus Gubitosi, a subpoena to Verizon for telephone numbers called from the defendant's telephone was valid, as the defendant had no expectation of privacy in the telephone numbers he called, as distinct from the content of the call. That was a split decision. The majority said, nothing in today's decision prevents the legislature from closely regulating subpoenas for phone records. And the concurrence said, among other things, I would encourage the legislature to examine whether telephone billing records should be protected from the reach of a prosecutor's subpoena. The New Hampshire Supreme Court has not yet considered the implications of the recent privacy informational constitutional amendment, which says, an individual's right to live free from government intrusion in private or personal information is natural, essential, and inherent. Now, what does this bill do? It clarifies the constitutional amendment with a legislative determination that the third-party doctrine, which allows access by anyone, including the companies, to the information that you've given them for that service. Third-party doctrine says that information is not subject to privacy protections. That this third-party doctrine does not operate as an escape hatch for providers of information and services to access personal information for purposes other than providing the service promised to the individual, the telephone service or the streaming service. There are exceptions in this bill. If the individual consents, and it has to be real consent, not just, you know, if you do our service, you've agreed to our terms, which we all do, but have no clue what we're agreeing to. No, this has to be real consent. Number two, there's an exception where the provider of information or services has a reason to believe criminal activity is occurring. There's an exception for state agencies if the information is required for them to fulfill their statutory responsibilities, provided the individual is first notified and has an opportunity to contest the request. There's an exception for information sought pursuant to a warrant based on probable cause. You've got a warrant with probable cause, you can have access to this information. There's an exception for 911 calls. There's an exception for emergencies, danger of death or significant property damage. There's an exception if it's otherwise required by statute somewhere else in the RSAs. And there's an exception for grand jury testimony, grand jury information, subpoenas. Enforcement in this case is by the AG only. A private right of action is specifically excluded. I can think of no more appropriate legislative determination as to what the constitutional privacy amendment means than House Bill 195. It's right on point. I would add only that there is an amendment that I think improves the bill. One of the things that I think is the case is that some of these service providers, in order to provide the service, the telephone service or the streaming service, use other people, other organizations to do some of the work. For example, they may store information in the cloud. And to the extent they do that, they have to give this personal information to the cloud provider. So I'd like to see an amendment to the bill which would go in section, 507I2I, or Roman I. If this would be E, this would be an exception. The personal information is disclosed by the third-party provider in order to provide the service which the individual has requested. So these companies can provide this information if the purpose of providing the information is to make sure I get telephone service. I think that would eliminate a lot of some problems that some of these providers have with the bill, and certainly would not in any way give access to this personal information where it would be inappropriate. I hope the committee will look favorably on this bill, and I'm pleased, Mr. Chairman, to answer any questions if there are any.
Representative Smith.
Thank you very much. Good morning, Mr. Chair. Lots of chairs in this room. It's important to recognize that. I do want to begin by saying we sent out a search party when we began this bill because we wanted you to be here for all of it. You missed the presentation of the bill. You missed the comments by a representative of the insurance industry. You missed the comments by a representative of the banking industry that indicated, by the way, not one but 4 different, I believe, federal laws that they were required to follow. You missed a very interesting presentation by the state police who felt that their need to move rapidly wasn't clear enough in the bill. And we showed the sections, but they didn't quite agree that. And somebody who represents some technical group, I couldn't quite get all the code names, but all of those were opposed to this bill, saying that it did not meet their needs, it wasn't workable, it interfered with their ability to carry out their responsibilities. And unfortunately, Mr. Chairman, you weren't here to respond. Based on what you, and the other thing is that there has been some legislation that has passed in the state since we began this process. So looking at this bill, you've now mentioned one area that you think could help improve the bill, and we're always happy to get that. Do you, however, see that the language of this bill interferes with the ability of those institutions that I referred to, banking, insurance, whatever, to carry out their responsibilities in any way that would be appropriate while recognizing the rights to privacy? It's a simple question, Rick.
Thank you, Representative Smith. It's one of your usual simple questions. I'm not sure how to answer it. I apologize for not being here. I was testifying on another bill before House ED&A, and I kept coming back and forward. Anytime you have an informational privacy bill, all those people who benefit from using that private information for their own purposes come out in droves and explain why the world as they know it will no longer exist. To some extent, this will impinge upon their ability to make money or do their jobs. But the question for you as policymakers is to balance the interests of privacy for the individual against the interests of these organizations, both to do their jobs, including making money. It's a tough decision, but that's what you're paid the big bucks for. When I did come in, I heard what I thought was a speaker, a person who was testifying, talk about Senate Bill 255. Senate Bill 255 has gotten a lot of hype, but it's basically a useless bill. In order for you to exercise any of the rights that you have under that bill, you have to engage in what amounts to a full-time effort to contact every company you've ever done business with, run through their unique individual way of exercising your rights, because each of the controllers in that bill can set up their own systems. It's about as useless as, it's about as useful as some of the bills that or some of the procedures that we now have for exercising our rights, which I mentioned before. When you go online and you want to use a particular site, they say you have to agree to all of our terms of services. And we agree because we don't have the time, and frankly, some of us, including me, don't have the ability to understand everything they're asking us to do. 255 is not helpful on privacy grounds. It's a great thing for Microsoft and the others who are pushing it because they were able to get something through the states that they couldn't get through Congress, and they can now tell their people, we really care about privacy. But it doesn't work as a practical matter. This bill works as a practical matter. And it's also in the New Hampshire tradition. If there are significant problems that some of these folks have with this bill, I hope the chairman will set up a subcommittee and try to work some of them out. If there are legitimate problems, let's resolve them. But the basic thrust of the bill is really important. When I set up a telephone account, when I set up a streaming account, when I use any service and give my information, I find it hard to believe that it's essential for them to sell that information for a profit in order for them to continue to provide me with the service. I know Verizon doesn't need to do that, and I don't know if Verizon sells this information or not. Remember, this bill is not only directed at for-profit companies, it's also directed at state government, which is why the police were in here. So I haven't answered your question as specifically as I would like to, Representative Smith, because I wasn't here, and I apologize again to hear the specifics of the issue. But that's one of the reasons why we have subcommittees to work on this bill.
One follow-up. Yep.
Mr. Chair, I have to say, are you aware of the procedures followed by the Schengen country, the European Economic Community, where you have a very clear choice to accept all the conditions, accept some of the conditions, or refuse to accept the conditions but still have access to the site?
I'm aware of some of those because I've read about some of them, but it's very complicated for me and I'm not totally familiar with them. However, when I do go on websites that are in Europe, I am always asked, what is it that I wish to do? And it's really simple. Reject all, accept all, and you can continue using the site regardless. That would be a delightful way if we could deal with privacy issues in New Hampshire in that simple manner. This bill is an effort to do that by, in effect, changing the rules that exist today, which say once you give that information up, it's theirs to use as they wish, by saying, no, they have to ask your permission. That's what this bill says. If they want to get that information and use it, they must get your consent. It's not as good as what the Europeans are doing, but it's a step in that direction.
Any questions? Seeing none, thank you.
Thank you.
Andrew Kingman. Just
Hi.
1 second.
Yep.
Mr. Kirk, do you have any written testimony that you could turn in?
I would like
We'd appreciate it.
I made the amendment.
Yeah. Oh, all right. Thank you. I apologize. Go ahead.
No, it's fine. And I do not have written comments with me, but we can provide that after if that would be helpful
Yes,
for
thank
the
you.
committee. Good morning, Mr. Chair, members of the committee. My name is Andrew Kingman. I represent the State Privacy and Security Coalition. We're a New England-based group that represents about 35 companies and 6 trade associations across the country on bills of this nature. I also have a background as a privacy compliance attorney helping clients work through various privacy laws. And we're here in respectful opposition to HB 195. There have been some questions about the bill that was passed last year. So I just wanted to start with what is in that bill to just sort of set the stage, because I think our position is probably, best summed up by Representative Perez's question, which is that last year's bill addresses almost every issue that is in HB 195. But does so in a little bit more thorough way with defined terms and much more kind of accepted framework for how to process personal data. So last year's comprehensive bill, the intent of that was to cover all sectors of the economy, all different types of companies, with the exception of some that are covered by federal law, like HIPAA or Graham-Leach-Bliley. And the reason for that, for treating all companies the same and all of the company's data the same is that we believe consumers should also have the same expectations and shouldn't have to have different expectations or controls based on the type of company that they're interacting with, right? So if I'm a consumer, I want to have the same expectations across, whatever company I'm interacting with as to how my data is controlled. I think, this has been stated before, so I won't belabor it, but that generally sets forth some basic frameworks. One is that you have the right to opt out of the sale of your data, targeted advertising, and profiling for certain types of automated decision-making activities. But you are required to provide consent, affirmative consent, and opt-in to any processing, which is defined very, very broadly, of sensitive data. And that includes terms that are defined in that law that are not defined in this law, like biometric data, genetic data, precise geolocation data, et cetera. These definitions in SB 255 is designed to be sustainable over time. So you'll notice that the definition in that bill of personal data is any data linked or reasonably linkable to an identified or identifiable person. It doesn't list out the types of companies covered or the exact types of data covered because it's meant to be adaptable over time as technologies change. It also, I would just take one note with something that Representative Kirk said regarding having to go through each company to exercise these rights. The bill specifically provides a mechanism called a universal opt-out mechanism, which requires companies to recognize certain browser signals that a consumer can put on their browser that says, opt me out of the sale or targeted advertising of my information without having to navigate through a specific site. I think the other basic framework of SB 255 that this bill doesn't recognize is this distinction between controllers and processors, as Mr. Gilrain flagged. But more specifically, this bill doesn't distinguish between them in a way that would require processors, which never interact with consumers, to be obtaining consent for them anytime they needed to do something with that personal data. And it would also require controllers, which are the consumer-facing businesses that most of us interact with, to obtain consent to provide, for instance, your address when you want to purchase something online. The transmission of that data to your processor that handles shipping would, under this bill, require consent, but only for certain types of data or certain types of entities, right? So again, we believe that SB 255 addresses the vast majority of issues that are brought up here, does so in a little bit more fleshed out way that also works with other New England states that have adopted these laws. And again, this law has only been in effect for 2 months. And so we think it's worth sort of letting that law mature and see if there are issues with it. And if there are, we're more than willing to address it. But, companies spent the last year working to implement the law that's just been in here for 2 months. So we think it's worth taking a moment to make sure that that law is working or to identify issues with it before we significantly modify it and do so in a way that doesn't really, work with the framework that's accepted there. So with that, happy to take any questions.
Are there any questions? Seeing none, thank you.
Thanks.
Rick Fabrizio.
Judiciary members, thank you for allowing me to speak today. For the record, I am Rick Fabrizio, Senior Director of Advocacy and Public Affairs for the Business and Industry Association, New Hampshire's leading business advocate. I will save time and not repeat testimony of the valid points that have been made already, but I want to focus on what I feel is the most important point to consider. HB 195 is unnecessary with enactment of the New Hampshire Data Privacy Act. That's the 507. that bill came to be law in part by the work of this committee. And I will pay you all the respect, as well as the full House, the full Senate, and the governor, that we did not pass a useless bill. Senate Bill 255, or the model legislation created by Senate Bill 255, has now been passed in 20 different states. These laws were necessitated because of lack of federal action on data privacy. And the model legislation was critically important to avoid a costly and patchwork of state laws that vary by state. The New Hampshire privacy laws, as has been mentioned, just went into effect January 1st. It is clear on what consent means, what is covered, and who is subject to the law. HB 195 fails on each of those standards. The benefits of model legislation should not be erased by unnecessary laws that confuse both consumers and businesses. Please allow our state data privacy law to fully take effect. It is just in the initial phase for this year where any violations can be cured on January 1st, 2026. The full effect of the law takes place. It does need time to see what works and possibly what may not work. With all of that, we respectively ask you to vote in expedient to legislate on House Bill 195, and I'm happy to take any questions you might have.
Are there any questions? Seeing none, thank you.
Thank you.
Maura Weston.
Good morning, Mr. Chairman, members of the committee. My name is Maura Weston. Thank you for the opportunity to be here today. I am here on behalf of the New England Connectivity and Telecommunications Association, known as NECTA. NECTA is the regional trade association that represents private cable and telecommunications companies in New Hampshire and several other New England states. Our members here include BreezeLine, Charter Communications, and Comcast. Together, our members service approximately 485,000 customers and offer broadband, mobile, video, and voice services to more than 695,000 locations in 185 New Hampshire communities. I'm here today to respectfully oppose House Bill 195. With that said, however, NECTA's members have been committed to protecting the privacy and security of their customers' personal information, and we look to our participation in prior sessions on House Bill 255 that resulted in New Hampshire RSA 507H as an example of that commitment. As you've heard, broadly, 507H establishes a privacy framework, creating rights for consumers, enforceable obligations on private entities that control or process personal data and sensitive data. And specifically, it creates an opt-in regime to protect truly sensitive data, as that term is defined. It also creates a mechanism for consumers to opt out of the use of data for advertising, sale, and profiling purposes, which terms are also defined. Importantly, it also creates a framework for how companies must communicate through their privacy policies regarding how they use data and who they share data with and for what purpose. This framework, as you've heard, is well understood by the regulated community, and compliance is widespread. Our primary objection to House Bill 195 is that it proposes changes outside of the framework of 507H in a parallel and really misaligned way. Within the context of the background and our knowledge of 507H, I'm going to point out a few specific flaws that we see in the language as drafted. The terms don't align between House Bill 195 and our current law. For example, House Bill 195 would require ISPs and cable television providers to obtain opt-in consent from consumers before disclosing or making available to any person a broad range of information, regardless of whether the information was necessary to provide an underlying service. For example, that limits information sharing between our members and their business partners, from anything from authentication technology to signing in and out of services to navigate across platforms, for example. 195 also seeks to protect individuals as opposed to consumers. This is important to point out, as it's an important distinction, because a company, for example, couldn't disclose under this law the names and addresses of employees, i.e. individuals, for purposes of payroll without first obtaining opt-in consent. Moving on, the definition of personal information is very broad and problematic in many respects. It does not distinguish between sensitive data, i.e. genetic and biometric data, as protected under 507H, and non-sensitive data that's available from public sources, names, addresses, phone numbers. 195 also uses vague terms like location information. We don't know what that means. Is this sensitive location data or all location data? Moreover, the phrase available to the public is used. It is unclear to us, and it is quite confusing in the context of looking at 507H when we also see a defined term, publicly available. So the lack of clarity really frustrates compliance efforts and enforcement, and it is problematic. 195 would upend the careful balance that we worked very hard to achieve in 507H by subjecting all personal information, regardless of sensitivity, to opt-in consent, thereby interfering with business and network operations. This really could impede digital commerce and degrade internet experiences. To the contrary, 507H recognizes every entity that uses data in one of two ways: the control of data and the processing of data. And you've heard about that again this morning. In summary, we believe that 195 is unnecessary. It does not provide additional benefits to consumers. We agree that 507H needs time to work. I do want to point out before I conclude that law enforcement requests are already addressed under current state and federal laws. Under federal law, the Electronic Communications Privacy Act regulates how voice, data, and video providers may disclose information to federal, state, and local government entities, and state statutes specify in detail the lawful sharing of information with law enforcement entities. As we've discussed, NECTA members are required to communicate our privacy policies, and those policies are legally enforceable commitments. In conclusion, we would urge you to recommend HB 195 inexpedient to legislate, as there are unintended and undesirable consequences. We do not believe that this clarifies the law in any way and would not serve the interests of New Hampshire consumers. I thank you for your attention and appreciate the opportunity to be here today.
Are there any questions? Seeing none, thank you.
Thank you.
Warren Cormack?
Good afternoon, members of the committee.
You were on. Yep.
Good afternoon, members of the committee. My name is Warren Cormack. I'm the Assistant Attorney General in the New Hampshire Department of Justice, who leads the Data Privacy Unit, housed within the Consumer Protection and Antitrust Bureau. I would be responsible for enforcing this law. The Attorney General is not commenting in support or opposition to this bill, nor commenting on the rights that it provides, opt-in consent or application to third-party providers. My testimony here today is to raise some issues with the language and structure of this bill. Currently, RSA 507H is enforced through the Consumer Protection Act, RSA 358A. And the Consumer Protection Act has certain penalties and enforcement ability built in it that would apply to 507H. For example, the Consumer Protection Act allows the Attorney General to seek injunctions for conduct engaged in by entities that violate the Consumer Protection Act or 507H. There's also subpoena authority, administrative subpoena authority written in 358A that violators of 507H would be subject to. And RSA 358A, the Consumer Protection Act, has $10,000 penalties per violation, up to $10,000 penalties per violation of that act. This bill does not have any provision for injunctions. It doesn't have any provision for subpoena authority, and the penalties that could be issued under this bill are up to $1,000 per violation of it. If the legislature is interested in passing this bill, the Consumer Protection Bureau would like to have the ability to stop harmful conduct through injunctions and seek meaningful penalties for violations of data privacy principles. And so there are two possible ways of going about this. If this were tied in with 358A, it would be subject to the exceptions in 358A. And so that's one way of going about it. Or if this bill had the added enforcement ability that's present in 358A, then it would bring it to the level where it would be able to be enforced similar to the way that RSA 507H is able to be enforced. Thank you.
Thank you. Are there any questions? Seeing none, thank you.
Thank you.
That's the last card I have for House Bill 195. Is there anyone else here that wishes to speak on it that hasn't turned a card in? Seeing none, I'm going to close the hearing on House Bill 195 and open the hearing on House Bill 522 relative to the expectation of privacy and personal information maintained by the state. I recognize Representative Lynn to introduce the bill.
Thank you, Mr. Chair, members of the committee. I believe this is the last time I will be up here, at least today. 522 is not a bill that we enacted or that we don't even think we considered it, to be honest with you, last year, but we certainly didn't enact it. As you can see, Representative Earth is the prime sponsor of this bill, and this bill, for lack of a better term, is kind of the flip, is intended as a complement to 195. 195 is directed at the third-party providers of information and services, and it prevents those entities from making disclosures unless the provisions of 195 are complied with. And as was just mentioned, that bill does not have a private right of action in it, because so that, in other words, private individuals would not be able to sue any of those businesses if there was a violation. 522 is directed to governmental entities. And it basically says that, I mean, the key provision, the way this bill is structured is, the key provision is RSA 507 I:2, Roman numeral 2. No governmental entity shall acquire, collect, retain, or use any personal information of any individual residing in New Hampshire from any third-party provider. So if you stop right there, you say, uh-oh, how's government going to do its job? Because that's the flat prohibition. But then, if you go on to paragraph 3, you'll see that there's a huge carve out of exceptions which basically says government can do its job. If there are reasons why the government collects information, and let's hope, I think this is the case, especially in a place like New Hampshire. Generally, government is not collecting information for nefarious purposes. They're generally collecting it for appropriate purposes. And in paragraph Roman numeral 3, which begins on line 29 on page 1 of the bill, over through line 28 on page 2 of the bill, that, or I'm sorry, not line 28, but line 23. It spells out all the proper reasons that government can obtain information. And then this bill, unlike 195, this does allow a private cause of action. And I think the rationale there is that that there are reasons why it may make sense to allow a private individual to have a cause of action against the government where it wouldn't make sense to allow them to have a cause of action against private businesses. And so that basically that's the rationale for that. So with that, I know Representative Kirk is here, who's also has a strong interest in this bill. I think it's a good bill. I think it does complement 195. I'm happy to answer questions, and that's about all I have to say.
Are there any questions? Seeing none, thank you. You can tell what time it is when people aren't asking questions. Neil Kirk. The Honorable Neil Kirk, I understand.
Thank you, Mr. Chairman. I'm glad to think you feel that I'm honorable, but I'm not sure what the correct procedure is for addressing a retired representative. Representative Smith probably knows. Honorable, thank you.
Honorable.
Good afternoon, Mr. Chairman and members of the committee. For the record, I'm Neil Kirk. I live in Ware, and I'm here representing myself. 522 is different from 195. 195 covered both the private sector and the government sector. 522 only applies to the government sector. So the various interests that might have testified against 195 would not be concerned with 522 because it only applies to government. Again, like 195, this does not deal with all privacy interests with respect to information and government. It only deals, again, with these third-party providers of information and services. So this is not a broad sweeping bill that covers every kind of information that government might seek. It only applies to the information that we provide to third-party providers of services and information, and it basically says when the state wants information from them, it can't get it unless, as Representative Lynn said, it falls under one of these exceptions. And the exceptions are very broad. Representative Erf and I dealt several years ago with a variety of state agencies to try to get the language that would allow them to continue to do their jobs and still protect privacy. And that, I think, is reflected on page 2. Line 1. This is an exception. Personal information acquired, collected, retained, or used by any state regulatory or administrative agency when such acquisition, collection, retention, or use is within the agency's regulatory, investigative, adjudicatory, or administrative function. And so the insurance department, for example, can continue to use or gain access to these various sources of information when it is fulfilling its statutory functions. The one issue which is addressed in 195, which is not really addressed here, it has to do with the state police or any police. The way this is set up, the cops would have to get a search warrant in order to get information from any of these sources. That poses a real problem for them. In 195, it was said they didn't need to get a search warrant. They could still use a subpoena, which, as you know, is an administrative kind of a device. But it required them to give notice to the person about whom they were collecting information and give that person an opportunity to contest the subpoena. That is obviously a problem for the police, and how that's worked out, I don't know. But that provision is not in this bill, and you might want to include that provision from 195 in 522. There's a penalty here. Individuals have a right to sue. There's a clause here which says if the federal law preempts this, the federal law prevails. This bill is not as broad as 195, and from my point of view, it's not as desirable. But I understand the opposition to 195, and if this committee decides to hold on to 195, to work on it, or to do something else with the bill, I would still recommend that you look to 522, modify it as you need to, because this does implement the privacy amendment and says and places limits on what state government can do to access our information. Representative Erf asked me, does this prevent the state from collecting databases or creating databases on individual? The answer is no. The state can create a database on individuals, but the only information that could go into that database would be publicly available information. So if I went on Facebook and posted a whole bunch of pictures and let the world see those, there's nothing in this bill that would prevent the state, and I don't know that they're doing it now, from starting a database on Neil Kirk and putting all of those pictures from Facebook in that database. But what they couldn't do in that database is including any information from telephone companies, internet providers, service providers, and so forth into that database. That would be prohibited under this bill, but not a database itself. Why Representative Erf was concerned about databases, I don't know. As far as I know, the state does not have databases on individuals except in connection with investigatory activities that are the legitimate function of agencies. To sum it up, whatever you do with 195, 522 should go forward. Modify it as you need to do to account for particular state agencies' issues. Thank you, Mr. Chairman. If there are questions, I'd be prepared to answer them, even if it goes into lunchtime.
Are there any questions? Representative Smith might have one.
I'm sorry, but I'm a little confused because you just said something about 195 with reference to the state police, and I was pleased to see that the representatives of the state police is still here, because I believe that the sponsor and others say that there is a very clear exception in 195 in situation, and I know we're talking about 522 now, but you've just combined them, so it's very important to note that there is an exception when an emergency situation exists and you can't go through the who struck John issue. You've got to just move very quickly, and I believe that what you just said seemed to contradict that.
There is an exception, and it does apply to state police. It's D on page 2, line 8, for an emergency. So the police could clearly get this in the case of emergency. But where it's not an emergency, where the police are investigating something, then the provisions of 522 would require them to would not allow them to get a subpoena, whereas they can get a subpoena in 195. So you might want to consider taking the subpoena language from 195 and putting it into 522 so the police can use a subpoena in appropriate investigatory cases.
Well, thank you very much. I mean, we're more concerned with the other. We're concerned with situations in which there just isn't time.
That clearly is covered by 522.
Thank you.
Not just for the police, but for any state agency.
Thank you.
Are there any other questions? Seeing none, thank you.
Thank you, Mr. Chairman.
Deanna Dennis?
Good afternoon, Mr. Chairman and members of the committee. For the record, my name is Dina Dennis, and I serve as Director of Regulatory and Legislative Affairs with the Community Power Coalition of New Hampshire. The Community Power Coalition is a joint powers agency established pursuant to RSAs 53-A and 53-E. We procure and supply electricity and related services to member community power aggregations on a default basis pursuant to RSAs 53E and also RSA 374-F2 Roman 1-A. Our members include 66 municipalities and 4 counties, serving approximately 200,000 customers across the state. Since launching Community Power Service in the spring of 2023, we've helped customers realize more than $22 million in savings on their electricity bills. We are respectfully opposed to House Bill 22, and our concern is actually quite narrow and pertains to Section 1 only, and specifically proposed RSA 507-I2, Roman 3, subsection E, on page 2, starting on line 12. And that's related to the condition that personal information be, quote, requested of and supplied by a third-party provider of information and services for named individuals only. We believe that that current language would prevent the continued operation of community power programs in New Hampshire, including those served by the Community Power Coalition. The Community Power Coalition and other community power aggregations are already subject and must comply with various state laws and rules related to data access and sharing, including RSA 363:37 and 363:38, which specifies what we as a service provider can and cannot do with respect to individual customer data. I've included in my testimony citations and relevant portions of these and other statutes and the rules in my written testimony for your reference and information. We believe that existing law provides that in order to launch new community power programs and enroll new customers into existing community power programs, the Community Power Coalition and other community aggregations rely on electric utilities as third parties to provide us with this data for all individuals, which includes personal information as defined in Section 1 of the bill. This data is needed since we are required by the Community Power Aggregation Act, or RSA 53-E:7, to mail written notification to each retail electric customer within the municipality or county service area where the community power program is provided. If we do not have the ability to receive this data from the utilities, there is no way for us to know specific named individuals, which is the approach proposed via subsection E. All that being said, we think that there's a relatively simple solution to address our concern, and that is to remove the provided that condition of subsection E, which is on page 2, lines 12 through 16, and as shown on page 4 of my written testimony. So what we're proposing is that subsection E would simply read as the follow. Cases where the acquisition, collection, retention, or use of personal information is authorized or required by state or federal law, period. And the remainder of lines 13 through 16 would be removed. So with that, thank you for your time and consideration of my testimony. I welcome any questions.
Are there any questions? Seeing none, thank you. Warren McCormack.
Good afternoon. My name is Warren Cormack. I'm the Assistant Attorney General in charge of data privacy enforcement in the New Hampshire Department of Justice, Consumer Protection and Antitrust Bureau. The Attorney General doesn't take a position on this bill. I testify to raise an issue with the language that might result in unintended consequences. The Department of Justice is a law enforcement agency, and this bill applies to regulatory and administrative agencies, but not law enforcement agencies. However, the Consumer Protection and Antitrust Bureau regularly receives substantial amounts of data from providers, from entities, after issuance of an administrative subpoena pursuant to their civil law enforcement authority. And these subpoenas are regularly issued against financial institutions covered by this bill. And it's a core part of the investigations of a lot of what the Consumer Protection and Antitrust Bureau does, like, for example, investigating violations of the Consumer Protection Act with respect to home contractors. Oftentimes, an administrative subpoena would be issued to a bank to look into the books of that type of a situation. So because this bill could inhibit the ability of the Consumer Protection and Antitrust Bureau to engage in consumer protection investigations, the suggestion is that law enforcement agencies be added to the list of regulatory and administrative agencies covered by this bill. Thank you.
Any questions? Seeing none, thank you.
Thank you.
That's the last card I have on House Bill 522. Is there anyone else here that wants to speak on House Bill 522? Seeing none, I'm going to close the hearing on House Bill 522. And it looks like we have about a half an hour before our next hearing. So I'm going to recess the House Judiciary Committee until 1 o'clock.
If you add law enforcement, what impact would that have on the state police? How would that change what they are?
order. And we'll open the hearing on HCR 11. And I will recognize the prime sponsor, Representative Greg Hill.
Thank you, Mr. Chairman. Good afternoon, everyone, colleagues. For the record, I am Representative Greg Hill. I chair Legislative Administration, and I'm here to introduce House HDR 11 for short. I will be here to explain why I filed the resolution and what it does. I should begin by saying this is not the first time this exact resolution was filed. In 2003, the resolution passed the House 213 to 142 and died in the Senate. I read the entire file, including the testimony submitted. I believe the reason some members of the Senate chose to let it die was a feeling that they didn't want to embarrass the court. From the testimony I read, it seems clear, though, that most of the justices, or most of the testimony, felt that the Claremont decision had laid a proverbial egg. In candor, I should also explain that much of my testimony here today was stolen from that 2003 historical record, for I too believe the Claremont decision was wrongly decided. With that as a backdrop, let me say the purpose of this resolution is to make it clear that we, the House and Senate, find the lines of responsibility between the judicial and legislative branches to have been crossed in the 1993 Claremont foundational decision. All subsequent Claremont decisions, but most especially the current Conval decision, a lawsuit, have doubled down on that original crossing of lines of separation between branches. HCR 11 is needed now as a measure of our resolve to defend our sworn constitutional responsibilities now and in the future. Our system of government is based on the system of our form of government is based on the system of checks and balances. One of these checks and balances is the separation of powers among the three branches. HCR 11 does not reject the theory of judicial review. It does not assert that the legislature or the governor can overrule court decisions, or even that courts cannot review legislation affecting education or tax policy. Rather, HCR 11 simply affirms the well-settled proposition that the power of judicial review is not the power to direct the other branches to pass legislation, and that consequently, by the directives of the Supreme Court in the Claremont decisions, that the legislature is required to pass certain legislation based on parameters set forth by the court. In other words, these are not binding upon the legislature. As we took office, we all swore an oath to protect our Constitution. I'll assume you have read and have an understanding of both parts of our Constitution. Part first is the Bill of Rights. Part second is the form of government. One of the many flaws of the Claremont decision was the justices finding the word cherish in Article 83 of Part 2, the form of government section, and succeeding in all sort of mental gymnastics to turn that into a right suitable for the first part of the Constitution. If you believe in the Constitution, and I think we all do, then you know precise words and placement matter. Those at the Constitutional Convention in the 1850s understood that well and tried unsuccessfully to put the words of Article 83 dealing with school funding into Part 1 by resolution. That resolution failed. Words matter and placement matters. Our framers changed a word from the Massachusetts Constitution that we used as a template when creating our New Hampshire Constitution. I've given you copies of both to highlight the significant change that was made. The word legislature was changed to legislator in our ratified Constitution. The framers, it seems, wanted the individual legislators to cherish education, not the entire legislature. Words have meaning, and I believe the justice in the trial court who first heard the Claremont testimony understood that. I've given you an excerpt, except it should be excerpt, of his decision that was overturned by the Supreme Court. It's page 3, and it says, New Hampshire's encouragement of literature clause contains no language regarding equity, uniformity, or even adequacy of education. Thus, the New Hampshire Constitution imposes no qualitative standard of education which must be met. Likewise, the New Hampshire Constitution imposes no quantifiable financial duty regarding education. There is no mention of funding or even of providing or maintaining education. The only duty set forth is the amorphous duty to cherish public schools and to encourage private and public institutions. The language of Part 2, Article 83 is hortatory, not mandatory. This decision is not often mentioned by those who feel the Claremont decisions represent gospel. Neither are the words of Justice Horton, who dissented in Claremont 2, but I have given you an excerpt of that dissent as well. He said, "My problem is that I was not appointed to establish education policy, nor to determine the proper way to finance the implementation of this policy. Those duties, in my opinion, reside with the representatives of the people. My job is to determine whether the structures for providing and financing education meet the mandates of the Constitution." The original drafters of HCR 14 from 2003 proclaimed, and I agree, that what the drafters of the Claremont decisions did was to claim innocence in words but cross the constitutional lines in action. The legislature and not the courts were given the exclusive right to make laws and spend money. I've given you a copy of Part 2, Article 5 in this package that clearly says just that. And so, while the courts say it is up to the legislature to define adequacy, a word the Claremont court made up, by the way, and devise a scheme to provide state funding by right, by dismissing every single attempt by the legislature to do that, they have effectively broken the intent of the Constitution that allows the legislature to make laws and spend money exclusively. This HCR makes clear that what I wish the legislature had done in 1993. Say clearly and loudly, "Thank you, justices, for your hard work and opinion on this matter, but our reading of the Constitution counts as well, and we'll act as we see fit. After all, we are elected by and represent the people of New Hampshire." With that, I'll end my testimony and ask for you to do nothing other than your sworn duty regarding our Constitution and protect the separation of powers. I understand there's a number of people speaking, and I would limit any questions to 1 or 2, Mr. Chairman. Thank you very much.
Questions for this witness? Representative Perez.
Thank you. Thanks for taking my question. Has this come up before last year when it came up, the issue about the Claremont decision? I mean, it's been since 1993, so it's been quite a while. Has it come up in the past that this is to our legislature, government?
I think it's fair to say there's quite a few people here that, thank you for your question, that are Claremonted out. I think there's been a significant number of pieces of legislation that have come before this committee as well as others. Not to mention, I think we're maybe up to Claremont 8 or 9 within the judiciary itself.
Follow up?
Yes.
Does this have anything to do with the fact that we have the education funding court case right now that's pending?
In the courts or in our?
No, in the courts.
It does only in the standpoint of what I said in my testimony, that each time a new set of plaintiffs come before the court, it seems the judiciary has gone even one step further in, as I said, doubling down on this separation of powers. What I'm trying to avoid here, and part of the reason for filing this resolution is, I don't see an end to these. It seems that every time a case comes before the court, the legislature tries to do something to appease that decision, and it lasts for a year or two, and then another court case comes. I don't see anything in this existing one, this Conval case, that's going to be the end-all case. I think we are facing a never-ending supply of plaintiffs and defendants, and that's what I'm trying to avoid, this endless supply of cases.
Thank you.
Thank you.
Other questions for this witness? Seeing none, thank you very much, Representative.
Thank you.
Next, I'm going to call on Representative Pam Brown, please.
Good afternoon, committee members and Mr. Chairman. For the record, I'm Representative Pam Brown from the towns of Kingston and East Kingston, and I also clerk on the House Education Funding Committee. I'm an economist and a college professor. I am here to express my very strong support for HCR 11. On our two education committees, policy and funding, we've been actively working to address and more clearly define two central issues: the appropriate scope of subjects to be covered in New Hampshire schools, and the appropriate level and method of funding education services in New Hampshire. We are well aware of the continued deliberations regarding these issues in our courts. I'm left wondering why the judicial branch has become activist concerning these matters, and how they have reached what appear to be arbitrary political decisions regarding Article 83, for example. I've scoured several dictionaries and the SRI. None of them indicates a close synonym for cherish is to fund or finance. In 1784, when Article 83 was established, I believe the average school had at most 6 or 7 grades. What is the exact scope of education levels to be financed? The court seems to assume K to 12, but why not grades 1 through 8? When basic reading and computational skills are nailed down, or K through community college, or K through grad school. Finally, estimates of adequate education costs are tied to debatable metrics measuring success. In the New Hampshire 2020 Commission report, it indicates that increased school attendance is an evidence-based measure of success. Attendance is an input, not an output, such as assessment results. So in short, New Hampshire's education cake isn't half-baked. At this point, all of the ingredients haven't been assembled. These are legislative matters and not judicial. I'll continue to watch the court's decisions and activities, but we're also going to be doing our work. Thank you.
Questions for this witness? Representative Perez?
Sorry. Thank you. Thank you for taking my question. Perception. Okay. I have a concern, and trust me, I'm a big constitutional person, but I have a concern about if they say we should do something and we don't do that, what is the perception to our constituents? Do you see any issue if the courts come back and say we need to increase funding, for example, to all the schools, all the public schools, and we say, well, we don't have to do that? Do you see an issue with what the perception on that would be?
I think the biggest problem is that the districts want local control of what they provide to their students. And they may want to limit it to basic subject matter. Other school districts may want to have a swimming pool or tennis courts. So when we look at the average cost of a student across districts, we have to really drill down and look at what each district is doing for their students. And some districts want to spend a lot with many bells and whistles, and others prefer just to have the basic skills and athletics and limit it to that. So to me, they really need to allow the local districts to decide what particular services they'd like to include in their budgets. And by mandating an average cost of education, they're really overlooking all of these details. And to me, that's just a local issue.
Other questions for this witness? Seeing none, thank you very much, Representative.
Thank you so much.
Next, I'm going to call on David Trumbull of where, New Hampshire? Trumbull?
Thank you, Mr. Chairman and committee members. My name is David Trumbull. I'm from the town of Ware. I oppose this bill for a few reasons. First, the resolution, I think, leaves out half of the New Hampshire Constitution's article on separation of powers. At the beginning of the resolution, in the whereas section, they mention the separate and independent branches of government, but that's only half of the sentence in Article 37. The second half of the sentence goes on to describe the three branches as having, quote, a chain of connection that binds the whole fabric of the Constitution into one dissoluble bond of union and amity. They're not completely separate branches of government. They're supposed to work together. Second, so what is the duty of the judicial branch? It's the duty of the New Hampshire Supreme Court, in the words of G. Allen Tarr, and he is the director of the Center for State Constitutional Studies at Rutgers and a professor of political science there. And he wrote an article called Thinking About Separation of Powers in New Hampshire. The duty of the New Hampshire Supreme Court is to say what the law is. Additionally, the New Hampshire Supreme Court has the duty to enforce the Constitution, as was explained by Judge Levi Woodbury. And all of us know that he was not only on our state Supreme Court, he was a governor, Speaker of the House, a senator, justice on the U.S. Supreme Court, and a Secretary of U.S. Navy and Treasury. He said that the rule of law was only one benefit that would flow from judicial independence. Independent courts, and only independent ones, could also help to enforce the Constitution. So the courts have two jobs. Tell us what the law is and enforce the Constitution. So the question is, did the Supreme Court overstep its bounds in the Claremont case? And I would say no. The court in Claremont laid out the framework for the legislature. One, it's the state's duty to fund an adequate education for all children in the public schools. And two, to define inadequate education. The court did this because of prolonged inaction on the part of the state, which failed to live up to its constitutional obligations. The court gave considerable deference to the legislature and the governor, quote, in Claremont 1, to fulfill their responsibilities to defining the specifics of and the appropriate means to provide through public education. And in Claremont 2, they noted the legislature would, quote, have wide latitude in choosing the means by which public education is to be supported. If the court had not pointed out the prolonged legislative inaction, it would not have been doing its job, which is to say what the law and to help enforce the Constitution. In those two cases, they didn't just come up with something willy-nilly. They went back to the 1700s. In Claremont 1, they cited Governor Wentworth, who made it clear in his address to the council chamber of the House of Assembly in 1771 that the duty to educate remained with the state. They cited the House and the state in 1795, which said the same thing. And they say this statement has significant probative value as an indication that the contemporary understanding of Article 83 imposed a duty on the state to provide universal education and support the schools. They didn't make it up. They went back. It's been the law of New Hampshire for 250 years. That brings us lastly to third, what's the duty of the legislature in this situation? If you choose to ignore court decisions, I believe that you not only would lead to less funding for education, but you would weaken yourself as a body. This is from an article in the American Journal of Legal History in 1995, another article on separation of powers in New Hampshire. Thomas Lowry, were the legislature to ignore the court's honest constitutional objections, legislators would severely undermine their own authority. Their laws would be exposed as mere acts of force, deserving no respect. The resolution focuses on the idea of independent branches of government, ignoring that they are tied together. If you weaken this, you weaken all of the branches. And I leave you with one other thought. If you can ignore the courts, then what's to stop the executive branch from ignoring you? When you make a law, it gets implemented by the executive branch. They pass regulations. The regulations, the common understanding is they must adhere to the law. The regulations can only fill in the details. They can't add to or subtract from the law. It has to be approved by the legislature. If you're capable of ignoring the court, what's to stop the executive branch from ignoring you and just doing essentially whatever they want? And then you would have 3 weak branches of government. We're better off with 3 strong branches of government that work together. In this case, you've got a clear directive that goes back 250 years. We should implement this long-standing duty of ours. And lastly, you have an alternative remedy. If you don't like the court decision, argue for a constitutional amendment to make it very clear. If enough people would support it, then that would solve the problem. But ignoring the court is not the correct step. Thank you.
Questions for this witness? Yeah, Representative Smith.
Thank you. What do you think would have happened if, these many years ago, the then incumbent governor had agreed to accept the Augenblick formula?
And so that would have, can you just spell that out a little bit more? I'm sorry.
Well, that's all right. I'll pass. Thank
Okay.
you.
All right.
Other questions for this? Yes, Representative Tripp.
Are you in favor of local control of the schools?
Yes.
Are you familiar with the phrase, who pays the piper calls the tune?
Yes.
Do you think that the state, should they decide to fully fund the schools, would be within their purview to take over control of local schools?
No.
Why?
The court in Claremont said that it pointed out the historical reason that the local school districts were created to help the state administer its duty. So local control, people have local control. The duty to fund it lies with the state. The control lies with the local towns.
Representative Horrigan?
I guess that's the flip side of this question, which was, do you feel that a school board which has more money at its disposal from whatever source has more control and more over what options it chooses to educate the students in its district, as opposed to one that doesn't have enough funding?
Absolutely. And if there's these 2 cases, you've got Conval and the Rand case. The Conval case is the base adequacy. The Rand case would be differentiated aid, so special ed and that. If the state were to live up to its duty to do base adequacy as prescribed by Conval, plus lived up to special ed, or at least say 60% of it, assuming the feds ever did their 40%, that would be a base from which any town in the state, even towns like Newport, would be able to have adequately functioning schools because they could add on what they could afford from their local property taxes. And if the towns that are more well off, they could do whatever they want to as well. But I think the state, the Constitution makes it clear, every town should be receiving from the state base adequacy plus special ed. That would be enough to allow every town to have a chance so that every child in the state gets a good education.
Other questions? Yes, Representative Perez.
Thank you. Thanks for taking me up. Correct me if I'm wrong, but it's my understanding that the case that is before the courts right now is to increase that base of adequacy education, increase that base. So by doing this, are we saying to them, if you say we need to increase this and we as legislators say we don't have to do that, do you feel that that's okay to do for us?
Thank you for the question, Representative Perez. So 2 things. The court is not saying that we should increase. The court was, the Conval trial happened. It went to the Supreme Court. Supreme Court said, not enough here. They remanded it back to the Superior Court for further evidence. They held a 3-week trial. They brought in dozens of witnesses, superintendents and finance people, and said, this is the bare minimum that we could do at a base adequacy, not looking at special ed, but just base adequacy. So they're not really saying let's increase base adequacy. They're saying what is base adequacy? And the Supreme Court instructed that trial court judge to determine how much does it cost to meet base adequacy. So that's what that judge did. He was instructed to do that. He did what he was instructed to, and that happens in cases all the time. Supreme Court remands back to the Superior Court, give us more facts. You don't have enough facts for us to make a final decision. So if that happened, I think the people of the state would say, okay, that's the way we're going to do it. It's the state's job to fund. Good. Then the state will come up with some funding source. And then, as I answered to Representative Horgan, then the towns would be able to, on top of that, add on whatever they wanted. Sure.
Other questions for this witness? Seeing none, thank you very much, sir. Next, I'm going to call on Caitlin Bernier. No, I don't. Hi.
Hi. Good afternoon, Honorable Chairman and members of the Judiciary Committee. My name is Caitlin Bernier, and I live in Merrimack. I'm here today as a taxpayer, a parent, and a member of our school budget committee. This was my first year on the budget committee, and I went all in. I spoke with everybody I could. I read all the things. I compared to all the different towns. I went in deep. And it was enlightening and also concerning. So fast forward to last night, we had our deliberative session for our school district budget. And the past few years, it's gone from like 20 people coming to like 400 people coming. So we had at least 400 people there last night. It was a big deal for us. And we heard from many taxpayers about how they can't afford another property tax increase. But they are seeing the progress from our students in reading because we have invested taxpayer dollars into prioritizing it ourselves within our district. The narrative of pinning neighbors against neighbors for one that is rightfully demanding an appropriate, adequate education for their young children, and the equally valid are our seniors and those on a fixed income with genuine concerns about affording the houses they raise their children in. This has been a familiar theme in recent years of my hometown and many towns in New Hampshire. Last night was different than I had anticipated in some ways, and it gave me hope. You see, throughout the budget season, many of us have been able to educate more of our constituents on the actual cost of providing an adequate education in 2025. We have informed them about the Conval and Rand lawsuits and how, unfortunately, little our state has been contributing to the future generations of New Hampshire. They have seen the decrease in funding over the last 10 years. They know that currently they're trying to overturn a ruling that requires the state to provide proper funding for our children's education. They know you're willing to spend money on the select few who use EFAs, but not the majority who use public school. They know that the tax burden falls on them when those they elected continue to fail them. So this time, for every one person who spoke about how they can't take the tax increase, I watched an average citizen who maybe has never spoken at one of these before go to the microphone and say that we need to hold the state accountable for how we have not been properly funding an adequate education, and to speak to their representatives. And each time the room broke out in applause. I'm here today on behalf of my community and our future generations that deserve better than your excuses. Be accountable and listen to your people when we say we agree with the Claremont and Conval cases and expectations of the state to uphold those expectations. The cost of educating a student has increased, and when I graduated from the high school that now I get to find out the budget on 20 years ago, our state actually provided more funding for our town 25 years ago than they do now. We have inflation, we have all these things that we say are the reasons everything goes up. But what's the reason yours is going down? And why are we just finding excuses and ways to say, maybe if we, pick this one verbiage, instead of just going, all students deserve to be properly educated and have an adequate education, and it shouldn't be at the cost of the parents. So that is all I have today. Oh, I'm in opposition. I meant to lead with that. I'm in opposition of this. And that is all I have. And I am open to questions. Thank you.
Questions for this witness? Seeing none, thank you.
Thank you.
Next, I'm going to call on Gregory Sorg, please.
Thank you, Mr. Chairman.
Welcome.
It's a pleasure to be back here. It's been
Welcome.
a long time. My name's Gregory Sorg. I'm a former 4-term representative in the New Hampshire House, all on this committee, and the last one as vice chair. I've been an attorney in the state since 1981. I'm a real estate practitioner. I work out of my house in Easton, and yet I'm in the strange position of relevant to what we're talking about here as being the attorney representing 27 House members and 2 senators as amicus curiae in the Conval litigation that's now going on. We were able to get ourselves involved in that case through the language of Article 83 of Part 2, which puts the duty that's under consideration here on the legislators, not on the legislature, as the parallel provision of the Massachusetts Constitution does. That means that what's under contention here is the content of the duty of each of you and all of your colleagues. And it's being hashed about in the Supreme Court in the Conval case by the judicial branch and the executive branch. They're going to tell you what the limitations on your authority is. Back in late 2019, Representative Hill and former Representative Balboni and I went to the Attorney General's office to urge them, the Conval case was then before the court, and to urge them to argue that the Claremont precedent should be overruled, because with each iteration of the Claremont case, in subsequent appeals, the court has involved itself more and more into policy areas that it's supposed to stay out of. What it's tried to do is to instruct the legislature as to what kind of laws they should pass. They won't order what sort of laws you must pass. They're not the precise laws you should pass, but to guide you towards what they want you to do, because they know they can't tell you what laws to pass. So if you pass the laws that they like, they can say, well, we didn't do it. We didn't make a policy decision. The legislature did. But the more they involve themselves in putting blinders on and narrowing the focus of the legislature, the more they're, in fact, making policy decisions, even though they're not saying so. On behalf of the legislative amici, as I called them, we filed several pleadings. We filed a brief in the 2020 appeal, which basically explained why Claremont was incorrectly decided. When it came back on another appeal in 2024, we filed a memorandum which basically was to remind the court of the 2020 brief and explain why and how the court should overrule Claremont. And both efforts were objected to by the plaintiffs, which is, to me, a rather absurd way of proceeding, because they are saying, in effect, that the legislature, even through these 31 of them I represented, should not have any voice in what's going on. while your future ability to legislate is being contended over by the executive and the judicial branches. The plaintiffs actually filed a motion to strike our memorandum, to which we filed an objection. And I go over this history because I've prepared for the committee a compilation of those 4 pleadings. Our brief from 2020, our memorandum from September of last year, the objection that was filed to it, or the motion to strike it, which was filed by the plaintiffs, and our objection to that motion to strike are in here, and I'll submit them to you. The current situation in the Conval litigation is that the latest appeal has been briefed and argued. It was argued last December 11th, I believe, and we're awaiting a ruling. The plaintiffs have asked the Supreme Court to enforce the order of the Superior Court, which basically orders the legislature to spend another $500 million in education funding to fund adequacy as it was determined by Judge Ruoff in the Superior Court. This is the culmination of 30 years of sparring between the legislature and the court on this issue. This eventuality was totally predictable back in 1994. I remember when I first read the Claremont decision, I could see where it was going to head. You could not comply with the Claremont decision in full, that is 100% funded adequate education, without a broad-based tax. And we know how much we talk about cherish, how much we cherish not having a broad-based tax in the state, an income tax or sales tax. And what the court did was place the legislature between the proverbial rock and the hard place. You either comply with the court and anger your constituents who put you in office to preserve New Hampshire as a state without a broad-based tax, or you do what your constituents want and repudiate the court. So now that we've come to the point where the court is on the verge, if they do affirm Judge Ruoff's order, we're in the position where we have 3 alternatives here. The judicial branch either backs off by overruling Claremont, or that failing, legislative branch either surrenders to the court, thereby betraying the wishes of your constituents and throwing the state into fiscal chaos, or you repudiate the Claremont decision via HCR 11 and thereby recover your constitutional authority as the exclusive state policymaker. Now, the opponents of HCR 11 claim that passing HCR 11 and repudiating the court would create a constitutional crisis. Well, I contend that we've been in a constitutional crisis since 1993, when the Claremont court knowingly and deliberately crossed the Rubicon by interjecting itself into education policy and funding matters. Now, I want to present a hypothetical here to illustrate what I'm urging you to consider. Suppose that a murder had been committed, the murderer apprehended, no problem knowing that he was guilty, and the trial is pending in the Superior Court. You had a very sympathetic victim, and the accused is very odious, and they got the evidence against them, but perhaps it was the search that recovered the evidence is kind of dicey, and it's possible that the case might be thrown out on a technicality. So in order to prevent that, the legislature passes a bill, and it does it with all the forms of legislation, whereas clauses, be it enacted by the Senate and the House of Representatives. And what the bill says is declares the defendant guilty and imposes a life sentence on him. And the governor signs that in the law, and it's duly enrolled, given a chapter number, and then delivered to the judge. Well, what would the judge do with that? The judge would repudiate. He would just throw it away. Why would he do that? It's because it would be a judicial act that was made to look like a legislative act. It crossed the line of the separation of powers. So my question to you is, shouldn't this work both ways? The Claremont decision was a legislative act all gussied up to look like a judicial act. It was very thinly disguised as such. In my brief, I explain why the court got it wrong, because they read something into the Constitution that isn't there. They read something out of the Constitution that was there, and they fabricated the historical data that led them to that decision. And they did that all in
7 pages. That's quite a threefer for such a short decision. So to conclude, I would suggest to you that legislators are required to to swear to the same constitutional oath as do judges. The judges violated theirs in 1993 and continue to as long as Claremont endures as precedent. The justices perverted their interpretive function to transform a policy issue into a constitutional issue. They used judicial forms to perform and provide cover for legislative acts. I urge members of this committee and of the House not to violate your oaths. Don't allow the court's intrusion into your constitutional authority to continue. I urge you to vote ought to pass on HCR 11 and start the process of reining in the judiciary, saving it from the consequences of its own folly and conceit, and restoring the legislative branch's exclusive authority to set state policy. I thank the committee for hearing me out.
Thank you. Questions for this witness?
Yes.
Yes, Representative Birch.
Thank you, Mr. Chair. As long as we're talking about oaths, and as members of the legislature, you know, we take an oath to uphold the Constitution of the United States and the state of New Hampshire. As attorneys, we take a similar oath. We're considered officers of the court. So I want to ask you, with those obligations in mind, when discussing a bill that essentially says that if the legislature decides they don't like what a court orders, they have a right to ignore it. So I want to give you a different hypothetical and ask. You're a practicing lawyer. You've got a bunch of clients who are, let's say, divorce clients. And they've been subject to a number of court orders. I'm wondering how you decide as an attorney which court orders you tell your clients not to pay attention to because they're somehow outside the court's authority, and which clients you tell that's a court order, it's your job to obey it, unless it's overturned through legal process.
Well, I'm just one person. I'm one attorney. I'm talking about an issue between two coordinate branches of the government here.
But I'm asking you, because you're testifying and making statements in support of this bill, I'm asking you how you would carry out in your own life this concept of judicial nullification.
Well, in my life, I would have the client obey the court order, no question about it. It's not
Thank
for
you.
me to decide which orders to obey or not.
Thank you.
But that's different. This is an institutional issue here.
Other questions for this witness? Yes, Representative Manos.
Thank you, Mr. Chair, and thank you for taking my question. I apologize, I didn't catch your name.
Gregory Sorg.
Sword.
S-O-R-G.
Attorney Sword, I wanted to ask you, you spoke about repudiation, but this bill that's before us is a House concurrent resolution. So is it not correct that it would, even if passed, would simply be a sense of the House? And this would not be binding on any way on an appropriation from the legislature or a non-appropriation from the legislature. This would not have the effect of a bill. Is that correct?
Not as I see it. It would be the legislature stating its sense that Claremont was not a legitimate exercise of the judicial function and therefore is not binding on the legislature. And the legislature thereby reasserts its own exclusive authority over the entire subject of the Claremont, which is funding of education and education policy.
Yes, follow up.
In your professional view, what would be the consequence of not following a House concurrent resolution, of a violation of a House concurrent resolution? What would be the consequence of that?
Violation by the House itself?
Well, by if the court did not comply with the House resolution, or did not, as you talked about repudiation, what would be the consequence?
Well, we go back to Alexander Hamilton when he characterized the judiciary as the weakest branch of government because it depends upon the legislative branch for its functioning. They have to pay for its facilities and everything, and they depend upon the executive branch for enforcing its orders. All the judicial branch has going for it is judgment. So if the legislative branch, through a solemn act like passing this House concurrent resolution, determines that this was not a legitimate exercise of the judicial function, there's nothing the court can do about it. You hold the whip hand here. I was constantly frustrated when I was here, the House, that the House and the Senate don't understand the extent of their authority. I was dismayed by the amount of authority that would be conceded to the judiciary and would be delegated to the executive administrative agencies. The legislature seems content to let other people make and enforce policy.
Other question? Oh, yes, Representative Peterno.
Thank you, Mr. Chairman, and thank you for taking my question. Earlier, we heard testimony that should the legislature resist the decisions of the court, that would weaken the legislature. But it seems to me, if I'm not mistaken, that what you are saying is that resisting a court decision would strengthen the legislature.
I've always felt that it would be a healthy thing if in an egregious case such as this, the legislature were to repudiate the court, because I think the court in the future would then pick its fights more carefully. What the court did in '93, I believe, is they just bit off a little more than they could chew. I think during the 80s and early 90s, there was a series of cases where the court seemed to be poking a stick at the legislature, and I couldn't figure out why this was. And I felt that it was like the court was testing the legislature to see how far it could go. And when Claremont came along, it was like an aha moment to me. They were setting us up for something like this, where they made a major intrusion into a policy area and figured the legislature is going to comply. They didn't realize how much resistance there would be, because they did not understand how much we would cling to our desire to be an economical state where local control of education is very important. That was what the Constitution intended, regardless of what you may have heard from the previous witness. That the evidence is overwhelming. The evidence cited by the court in the Claremont decision was dishonest because of what it didn't say. It took a few excerpts from speeches and letters, which the thrust of them was that, yes, education's important, but what really matters is what was actually done in legislation before, during the constitutional period, and afterwards. And it's quite plain there was no state funding at all for education until the 1850s. But the court found that to be not convincing. I don't know why. That would be the very best evidence of what was the intention of the makers of the Constitution, what the legislatures in the immediately following years actually did. And they did not provide state funding for education. What they did, Article 83 working in conjunction with Article 6 of Part 1, is they directed the towns to provide education at the town's expense. That was how Article 83 and Article 6 worked together.
Other questions for this witness? Representative Horgan.
Thank you very much. I don't know whether you consider it an extenuating circumstance or not, but 1993 was 32 years ago, so we're in, I guess, our 16th biennial budget cycle since that decision came down, and hasn't the legislature, notwithstanding Judge Ruoff's hearings and various other ones, managed to get away with passing budgets every 2 years, which provide a level of so-called adequacy that's far below what it actually costs to educate a student, and without really an adequate statewide funding. So haven't we actually gotten away with not funding education according to the standards of the law as it was back in 1993? So haven't we kind of triumphed over the courts in this ongoing battle? So.
Well, to me, it's been like a rope-a-dope strategy. The legislature has been in a state of denial over what the implications of Claremont 1 were. And so the legislatures, I don't know what was in the minds of my fellow legislators when they passed these bills, whether they really honestly believed these complied with Claremont or they didn't. But to me, they plainly didn't. But they would pretend they did. And then that would just lead to another school funding suit. and a little more cajoling from the court, which, as I said before, gets them more and more into policy making. And then another bill comes, and then we end up where we are now, where finally it's all come home to roost. We have the Conval decision where if it's upheld, will result in a massive tax increase in this state to fund education according to the figure for adequacy that Judge Ruoff determined. So the legislature can't play around anymore.
Follow up?
Yes, but wouldn't it alternatively be within our powers? Even, I mean, this would be an unpopular decision. There'd be a lot of pushback to just put through a massive tax increase, which would hopefully would be offset, at least to some extent, by lower local property taxes, and actually fund education adequately. So isn't that an option that's before us this budget cycle? I mean, not the option that's likely to be taken, but isn't that an option that faces the people down the hall who are writing the budget to actually go ahead and fund education adequacy and put this home and obviously increase taxes and put the matter to rest that way? I mean,
Well, I'm just getting in personal opinion here. I think the appetite of the schools for money is just limitless. So any tax you made would never be enough. And I'll tell you also, I grew up in Illinois, and I remember very clearly that in the late 60s, the voters were sold on a state income tax on the promise that it would reduce property taxes, and I'm sure it did for a couple of years. But then pretty soon they're both right back where the property taxes are right back where they were, and then you have an income tax, and I think that's the way the income tax has been sold in a lot of states. The promise that property taxes would be lowered, and it just doesn't work out that way in the long run.
Other questions? Yes, Representative Smith.
Trying not to ask a question. Is your concern that you believe that the judicial branch has overstepped its boundaries, or is your concern that the monster that some people think it is of an income tax would be the only way for the state to, in fact, meet its obligation to fund education?
I very much appreciate that question, because this is something I would have liked to have said it, and I should have said at the outside. As far as education policy is concerned, I'm just agnostic. I've seen my role in this as being to reset who makes the policy. I don't want the judicial branch setting education policy. When the judicial branch engages in truly judicial acts, I'm a great admirer. We are very lucky to live in the state, and we have a very good judiciary. But back in 1993, they went off the rails in this one case, and I just wanted to restore education funding policy and decision-making to where it belongs. But as far as what policy the legislature in its wisdom decides, I'm neutral. I'm a process guy, in other words, not a policy guy.
Other questions for this witness? Seeing none, thank you very much, sir.
I'd like
Next.
to submit, Mr. Chairman, I'd like to submit.
Oh, of course, yes,
these
absolutely,
pleadings.
absolutely. That's fine. Next, I'm going to call on Zach Sheehan of Concord, please. Thank you very much. Nice seeing you. Thank you.
Good to see you, girl.
Good afternoon, members of the committee. My name is Zach Sheehan. I'm the executive director of the New Hampshire School Funding Fairness Project. I have some testimony I can pass out, offer, and we'll try not to repeat what's already been said. I know we've been going for a bit here, but a little bit more context around, we're in opposition to both HCR 11 and HCR 7, which will be heard next. I think it's important to provide a little more context around kind of why the Claremont lawsuits were initially filed and why we've had ongoing lawsuits over the years that have been referenced throughout the hearing today. Currently, there's a gap between what the state has determined to be the cost of an adequate education, averages out about $5,297 per student. That's current figures. When actual expenditures, average expenditures across the state are closer to $22,000 per student. As average expenditures, there's no school district in the state that spends less than 3 times the amount of funding that they're getting from the state in adequacy funding. That is the same context under which the Claremont lawsuits were filed, significant lack of funding from the state to provide these services to school districts in specific communities with much lower property tax rates and higher property tax burdens. Only 20% of all school district revenue actually comes from the state of New Hampshire. That's the smallest share in the entire country. Whereas we rely on 70% about comes from property taxpayers, which is the largest share of school district revenue that comes from property taxes by a long shot in the country. These resolutions really are going to entrench more of the disparities, right? These are statements that are looking to push back on the rulings that have been made. We've heard a lot about that. And to some of the conversation earlier, the legislature has to date not been passing budgets or policy that has moved towards the Claremont rulings, which is why there are continued lawsuits. There are continued lawsuits because there continues to be a lack of funding from the state that provides an adequate opportunity for an adequate education to every school district in the state. The court, to go back to the kind of conval rulings, the court has been very clear. And when they were deliberating, when the court case got remanded back down to the Superior Court to Judge Ruoff, he was very clear in thinking through what is my role here in this debate. If I say that the $4,100 at the time in base adequacy, right, that's the amount of money just for the bare minimum that's providing for base adequacy for education. If the $4,100 the state's providing is not enough, but I've been told by the Supreme Court to come back with a number, and I say it's $4,101, right? That wouldn't materially change anything. The lawsuit would probably turn around and come right back. A dollar increase is not going to change anything. And so he was very clear in his ruling, this is about base adequacy only, that the 7356 figure that he came up with was a minimum, and that it was the legislature's job to go and figure out what the actual number is, actual cost of an adequate education, but that should be the floor, given that the floor of $4,100 was not nearly enough. This would be a shift of close to $500 million. The order does not say to increase funding by $500 million. It could and should be a shift of who is paying for that from local property taxpayers to the state. Relative to judicial overreach, which I think is what was testified as kind of the impetus for this concurrent resolution, there's been a lot of suggesting judicial overreach. Judge Ruoff again addressed those potential concerns in his conval ruling, and I'll just read a quick quote from him. This is a quote from the conval ruling. The court is likewise cognizant that school funding is a complicated and politically charged issue with a history that suggests some level of judicial intervention is now necessary. Among other things, though the legislature hired Dr. Baker to analyze school funding issues and provide an informed recommendation, base adequacy aid is currently funded at less than half of his recommended levels. This is just one example that calls into question whether the politics of this issue are impeding the state's constitutional obligation to fully fund the opportunity for children in the state to receive an adequate education, end quote. So there's a recognition there that, and this was brought up earlier, we have decades of legislature making some changes to school funding law, and then court cases coming back saying you're still not providing enough in base adequacy. There's a heavy reliance on local property taxes. The legislature making some changes, but not enough, and more court cases. And he's addressing that there's the political element of this issue might be, in our opinion, also is what is holding this from moving forward. So HCR 11 is, we should be spending time working on a solution to our school funding problem, relieving the burden on property taxes, sending more funding to districts that need it most. We know how to do that. There's many policy mechanisms, not having the legislature dig their heels in more. I'll end with one last point. I'm happy to answer any questions. We've heard a lot about kind of what constituents and people want on this issue. Just to, for the record, the online sign-ins for HCR 11, there's 19 folks in support, and as of a few minutes ago, 438 opposed, and then HCR 7, 3 in support and 400 against, just as a measure of kind of how other folks are weighing in on this issue. And I'm happy to answer any questions.
Question, Representative Oregon.
Actually, I was doing some quick calculations with the
Oh, I'm sorry. I thought you had your hand up. If I
Oh, well, I guess the last question. Do you have a figure?
Why not?
Maybe
Why
you don't
not?
have this off the top of your head, but do you have a figure on like how much is spent in total on public education in the state?
Total expenditures from everyone or just the state?
Yeah, both the state and the school districts.
I think the most recent figure is we spent about $4 billion all in our public education system here in the state. And you're showing my top of the head math. 20% of that is what's coming from the state. I don't have that top of my
Okay, good. Thanks.
Yeah.
Other questions for this witness? Yes, Representative Alexander and then Representative Peterno.
Thank you, Mr. Chair. Thank you for taking my question. Does your organization have any evidence to show that increased school funding will increase student outcomes?
Absolutely. There is a huge body of evidence. What you're referring to is this question of, does money matter? That's kind of the lingo that's used relative to researching what is the impact on funding on outcomes. And there's a huge body of research that shows that more funding, not just, more funding everywhere for everyone without cause for circumstances. But we know that increasing funding, especially for communities that have higher proportions of students coming from low backgrounds, have higher proportion of students who have disabilities, there's plenty of evidence that shows that that does have a positive impact on student outcomes, on student success rates, graduation rates, kind of whatever metric you'd like to use. There's plenty of evidence that shows that both in New Hampshire and nationally. And it's the does money matter is kind of the framing that's used to answer that question.
Representative Peterno.
Thank you, Mr. Chairman, and thank you for taking my question. So I've been watching with interest as school districts across the state have been increasing their budgets, in particular this year. I know my own local school district, the budget is increasing by 8.67%. And my question to you is, wouldn't increasing adequacy just encourage the school districts to spend even more? Because they can just, if we are getting they're now getting more money from the state, now they can offset and raise the local property taxes. They just seem to keep raising their budgets.
I think what's interesting about budgets going up is it's a reflection of true costs. But right now, I'm not sure what community you live in off the top of my head, I apologize. But the community you live in and many others around the state that are proposing and passing increased state budgets, who's paying for that is local property taxpayers. So you're having very local, very specific debates and conversations about if we increase this now, 8 something percent, we are going to pay for pretty much all of that, and that's passing. From our perspective, that shows New Hampshire as a whole, we have a deep commitment to our public education system. Even when we are the ones footing the bill as property taxpayers, we are willing to invest and continue to invest in our communities. The nuance there is not every community can do that. Some communities are proposing 8% increase, and their property taxpayers are paying rates that are 3 or 4 times the rate of their neighbors. And that they don't have that choice to say, should we increase our budget to, increase the teacher pay or whatever it is. And so from our perspective, and I think there's evidence to show this from when SWEP, the statewide education property tax, was passed in 1999. It was a new additive tax at $6.60, right? Brand new property tax around the state. Paired with an education funding formula to the previous question where money was directed towards communities with highest need. You added a $6.60 tax rate to everyone's bill. The average property tax rate dropped $4 per thousand in the state. And that's because when you gave more funding to communities that were really struggling with their property taxes, sure, they might have increased their spending, their budgets a little bit, but they pass a lot of that on to property tax savings. And with that comes back to that local control issue of if districts have more funding from the state, they have the ability to make those decisions locally. And we saw that in 1999 where a large infusion of new cash with a new property tax resulted in many communities, the ones that struggled the most, passing those savings directly on their property taxpayers. I hope that was helpful.
Other questions? Yes. Go ahead, Representative.
Yes, thank you, Chair, and thank you for the question. So I was just looking at some facts here about the Department of Education, the U.S. Department, not the local one here. The year 2000, it was $33 billion of outlays, 4,900 employees. Last year, went from the $33 billion 25 years ago to $251 billion, and only 4,200 employees now. How much of the funding comes from federal government?
So just to clarify your question is how much of the funding of the $4 billion I mentioned for the total funding in New Hampshire comes from the federal government? 9% this year. We expect that to be, it's normally around 5 or 6%. The past 4 years, it's been much higher because of COVID-related funds, but we'll see that drop off in the next year. So we expect we're peaking out right about 9% of total education spending is coming from the federal government.
Other questions for this witness? Do you have a follow-up? Go ahead.
Yeah, a follow-up question is whereas if you've seen the news lately, the DOE at the federal level is on the chopping block, so to speak. If that funding is shifted to local schools or local, state level, how would that affect this?
So just so I understand your question, if the amount of federal funding that we're currently getting stops or is reduced, if the federal funding increases, so I guess I'm not following. So my understanding of the conversation at the federal level is not that they are considering increasing funding to the states. It's that they are considering decreasing funding, if anything. So I guess to answer your question, if we got more money from the feds, that would be great. It would, I think, reduce a lot of these tensions that we're talking about. I don't think that's the direction that the conversations are going, at least my understanding of the federal conversations.
Thank you. Other questions for this witness? Seeing none, thank you very much, sir.
Thank you.
Next, I'm going to call on Sandra Cannon, please, from Atkinson.
Thank you for letting me speak. I just wanted to say that, can you hear it?
Can I get you to get a little closer to the microphone? Thank you.
Okay. Thank you for letting me speak. I just really want to point out that what the woman from Merrimack said about how local communities are doing it, she made some good points there. I also feel that the judicial, even though the education committee hasn't been listening to them as a constituent, I feel like they have to stay somewhat involved to try to keep pushing that. And if all of a sudden they're cut out, then there's no reason for the education committee to do anything. I'm also really concerned about the education freedom accounts, which there's absolutely no accountability for our tax dollars going to that. I do see a court case coming probably concerning that, since there's no way for us to have any information. So if we're going to stop all this, then that means that the courts can't get involved in another issue related to education. I also want to go that the perception is, with all these court cases, the perception is that the education committee is doing nothing. We are getting no more funding at all. There was even a bill that came up, House Bill 550, to increase the amount of money to that $7,000 that Zach talked about, and that was shot down in committee. And I just feel like they're not listening, and that all this burden is being put on taxpayers, okay, to fund education. We're not asking, Zach isn't asking for a lot more from the state, but enough to make it a little bit better. I don't know how many of you have heard about the Timberlane tax revolt that happened this year. Taxes are a huge issue for homeowners. And to put it in perspective, the dividends and interest tax was phased out. That affected the rich. The business taxes were decreased, okay? Nothing has been done for the homeowners. And I feel if the judicial is no longer involved in any of these education issues, that still nothing will happen, okay? But the Timberlane tax revolt at our deliberative session this year, our budget that was proposed by the school district and the budget committee was a decrease, okay, by about, I'm not sure the numbers, but it was a decrease. We were going to bit less on our taxes. And then a group came in, and if you want to read the article, it's out there online. A group came in and slashed our budget by $6.7 million, down to $81 million, where the school district says $83 million is what we have committed. And our budget was $88 million. So there was some wiggle room in there. Maybe it could have come down a little bit, but it went all the way to 81 million. Now, if that passes, because people are fed up with the taxes, that's going to hugely affect our school district. And I just really feel that I want the judicial to stay involved, to keep putting pressure on the education committee to do what is right.
Representative Pedro.
Thank you, Mr. Chairman, and thank you for taking my question. Are you aware, by any chance, that in the last biennium, the legislature increased funding for public schools by $169.1 million?
I don't know the numbers on that. I know they have increased it for education freedom accounts and that they want to open that up to a lot more people. They seem to have money for that, but not money to increase for the public schools.
Do you follow up?
Thank you. Thank you, and thank you again for taking my question. Are you aware that the funding for education freedom accounts accounts for less than 1% of the overall education spending in the state of New Hampshire?
It is right now, but if it gets opened up, it's going to be a lot more. And I feel like public education is important. The country's built on public education.
Any other questions for this witness? Seeing none, thank you very much. Next, I'm going to call on Anne Marie Banfield, please.
Good afternoon. Some of you may know me because you've seen me in the education policy group. My name is Anne Marie Banfield. I'm an education researcher. I'm a parental rights advocate in New Hampshire, and I focus on academic excellence in the classroom. And I've been doing this for 20 years, and I haven't collected a dime. So what we are seeing right now, and I think we can even see it in this room, is there seems to be, let's blame the state for sometimes irresponsible school budgets. And I say irresponsible school budgets because I look at them. I served on the Bedford Taxpayers Association for 10 years. I'm now running for Budget Committee in Northampton because I dig deeper. And what I find sometimes going on in schools is, quite frankly, wasteful spending. Now, I'm making that statement not for every single school, but I'm saying that I see it. I see it in my district. I see it in other districts. You mentioned something about increased spending gets you better results. When I lived in Bedford, we had great results, but what it doesn't account for is all the kids that go to private tutoring in Bedford. So there's a lot of information in some of these scores that are not always apparent. So you could increase spending all you want in your schools, but if you're not still providing a good education, the parents in the rich districts are going to make sure their kids don't fall through the cracks. So yes, I do look at what's going on in the schools. I thank the attorneys who came up here. I'm certainly not going to speak on that because I'm not an attorney and I'm not going to speak on that. But I am going to tell you that, for instance, in Merrimack, they spend $90,000 on a math program that includes social emotional learning and it includes fine arts. And I have to ask, where's the math? So when I look at scores, when I look at where the spending is going, and they have multiple programs in their schools, my question to you is, do you just want to give that over, more money, or would it be, I'm a lobbyist. I come to the education committee and I tell them about these issues. I would like to go to them and say, you know what, there are probably some schools in the state that need funding. And we need to focus on them. Teachers are having to purchase their own materials in their classroom while we're spending $90,000 on a math program that many teachers don't even like. So those are the kinds of things that I get to do as a lobbyist. But guess what? I can't go before the judicial branch and say any of this because that's not my role and that's not the role of the judicial branch. So now we've got them making these decisions that I can't weigh in on and explain some of this to you or explain some of it to the education funding group committee. I'm sorry. So that's why I think it's important to take back this role of legislators and stop letting the judiciary branch basically do your function. And now it allows me and allows other people with differing views. Maybe there is a school district that needs money. Let them come up and tell you. Let them come up and tell you, look, this is what we've got going on. But I'm telling you, in Northampton, we're spending $39,000 per student in our district if our budget passes. And our budget is pretty much close to the default, so it's going to pass. So we're spending $39,000 per student in my district. And it's up to me, when I run as a budget committee member, to now decide on what, and I engage my budget committee to the point where I'm probably an irritant. But seriously, I do engage in this process, and that's what we all can do in our own local towns. But I don't get to do this with the judiciary branch, who gets to now interpret law. And yes, I do see it as an overreach. Did you know that most administrators at the SAU level are making more than the governor, the commissioner, and the attorney general in almost probably every school district in the state? So there's ways that we can bring down property taxes if we really wanted to. The problem is that most local communities don't want to do that hard work. They don't want to make those decisions. And so that's why a lot of times the state give us more money. You're not giving us enough. Well, maybe it's because, like I think the governor pointed out, and I think Senator Carson pointed out, that we're not going to fund your bad decisions, or we're not going to fund your overspending. And I would agree with that. But at the same time, I do understand that there's a need for schools to get the funding. I just want to make sure I've hit everything up. I think I have. Yeah, that's all I wanted to say. Thank you.
Thank you. Questions for this witness? Seeing none, thank you very much. Is there anyone else here who wishes to be heard on House Concurrent Resolution 11? Seeing none, I'm going to close the hearing on House Concurrent Resolution 11. And I'm going to open the hearing on House Resolution 7. Hang on. And I will recognize the prime sponsor, Representative Belcher.
Good afternoon, Mr. Chairman, members of the committee. Very much my pleasure to be here this afternoon to introduce this. For the record, Representative Mike Belcher, Carroll County District 4. First, let me say that despite this body recently demonstrating that it does have an appetite to exercise its impeachment powers when warranted, as a point of clarity, this resolution is not articles of impeachment, and should it pass the House, it does not affect impeachment. Rather, it authorizes a House investigation, most probably taking the form of a brief special committee to look at the issue, investigate the issue, and render a recommendation on whether to proceed with articles of impeachment. There is substantial cause at present to believe that impeachment may be an appropriate remedy in this case. It appears that the judge in this particular decision is guilty of the following: usurpation of the exclusive powers of this legislature to both allocate funds and levy taxes, extreme judicial activism on behalf of a partisan political cause, thereby seeking to bypass us as the political body, and perhaps more importantly, bypassing the people of this state who elected us to represent them. 3, imprudence and usurpation of the greater powers of the New Hampshire Supreme Court by refusing to stay the order pending a review by the only constitutionally established court in this state, the Supreme Court. Allow me to provide some brief preemptive answers to some of the arguments that you might see against this. First, it might be argued that the financial calculations utilized in this opinion were good and correct. However, it can also be argued reasonably that they were not good and correct, and that a variety of other paradigms exist for funding of public education that were not considered here. The existence of these alternate paradigms fundamentally makes this a policy issue. And a policy issue is fundamentally a political issue. And this is the political branch of government. The judiciary is supposed to be apolitical, making findings of fact and faithfully applying the law. That is the extent of the judiciary's delegated authority. Second, it might be argued that the judiciary is a co-equal branch of government and therefore should be able to render this sort of opinion. Setting aside the previous argument that proves the general falsehood of that, it's also specifically false. The only portion of the judiciary that enjoys a co-equal status with this legislature and the executive is the part of the judiciary established by the Constitution, which is the Supreme Court of New Hampshire. The lower courts, by contrast, are not co-equal. They exist under this branch of government and regulated by this branch of government. Therefore, not only was this decision extreme overreach usurping legislative authority, it was also usurping the co-equality of the Supreme Court. Third, it might be argued that this opinion is a logical extension of previous Supreme Court precedent. However, the reality is that this decision so far exceeded any prior New Hampshire judicial decision that even assuming a full agreement with all previous precedents, this cannot be reasonably extended as a logical extension of them. No prior judicial opinion has made specific and radical funding demands of this body that also implicate the taxation authority of this body. We're talking about an amount of money here that is somewhere between 5 and 6%, I think, of the biennial budget represented just in this judicial decision. Fourth, it has been suggested that such impeachment proceedings might threaten the independence of the judiciary. That argument lies entirely on a faulty premise. The judiciary is no more independent than the executive or than the legislature. We exist as co-equal branches. That doesn't mean the same. It means we have different delegated powers with which to hold each other accountable and responsible to the Constitution. In this light, these arguments for judicial independence to prevent us from weighing in on our own territory of policy is little more than an argument for judicial supremacy and a form of oligarchy. That is not what we are. In summary, it appears to me that this judge, in this case, thought himself king of New Hampshire. That duty to correct this error is ours alone. Nobody else has the authority to fix this problem. If we fail now, we can and should expect that the next decisions rendered will be even more radical, and we might just find that our Republican form of government is irrecoverable if we do not act now. Thank you, and I will take questions.
I'm sorry, questions for the Representative Horgan?
Yes, I guess there was a Kontuka versus New Hampshire in 2019 and 2024. I haven't looked at the court docket for, I guess there's two court cases rather than one. So that, I mean, I guess we can get this, we can get this through our own channels. Was that something you can provide the committee so you can see like exactly what it is you're talking about, what it is you're complaining about?
I'm not entirely sure I understand the question.
I guess the other question is, what's the status of this case in the courts? So like I know he made an order which then was upheld, I think it was upheld by the Supreme Court. I was just sort of looking.
Thank you.
But then there's a second lawsuit, I guess, too. This filed last year, I guess, or is that correct?
Let me take the first question first, then you can repeat the second one because I didn't quite catch it. So the first answer would be, it is my understanding that the Supreme Court did step in to stay this decision, thankfully, where the judge himself had refused to stay it. And it's now being seen before the Supreme Court and pending a decision, which is why I think it's even more important right now to take some action. And again, passing this resolution does not mean impeachment. It means investigation that might lead to impeachment. And I think it's extremely important that we signal to the entire judiciary that this branch of government takes our powers very seriously and we're prepared to take action on it. Because the last bill you heard was talking about effectively what could be called the constitutional crisis. And if you don't want a constitutional crisis, you need to prevent it before the decision happens.
Other questions for this witness? Representative Tur.
Yeah, thank you, Mr. Chair, and thanks for taking the question. I think I heard in your introduction of the bill, you claimed one of the issues leading to this was judicial activism on a partisan political cause. And I was hoping you could clarify that. Are you saying that the funding of public education and how it's paid for is, in fact, a partisan political cause?
Yes, absolutely. There's multiple different paradigms by which a public education can be offered. Presently in this state, we have not just a traditional government-run schools, we also have EFAs and other available options for people to provide a publicly funded education to their children. And we fight all the time. You can look at the partisan breakdown of the votes. Of course, these are partisan issues. And of course, that's what the judge was weighing in on.
Other questions for this witness? Thank you very much, sir. Next, I'm going to call on Caitlin Bernier, please.
Yep, there you go. I've done this already. Good afternoon, Honorable Chairperson and members of the Judiciary Committee. Thank you for taking the time to listen to my testimony. My name is Caitlin Bernier, and I live in Merrimack, and I'm here in opposition of H.R. 7. I understand that there is the separation of powers and that the gentleman before was just speaking about how they're ready to be acted upon here and that action is going to be done. But this was at least 5 years ago that this first one came out, and we've had continued lawsuit or cases that you guys have spoken about where you're saying that the committee is going to make a decision and move on increasing the cost or of adequate education or base aid, and none of that has happened yet. So I can understand that everybody has your own place and role. But if things aren't being done and the increase isn't there, how else are we supposed to get anything improved? Who is going to take action? Who is going to make sure that we increase and take care of our students and our community? The comment before about property taxes, we in my town, in Merrimack, which was already spoken about, we did approve the budget because we do value our education, and we have seen our reading scores are above the state average across the board for all grades, because we have invested extra money and gone above and had hearings to approve things
You know,
for.
I don't mean to interrupt, man, but we seem to be getting a little.
Yes,
bit-
sorry.
This
I
is
did
the,
get a
this
little-
is- the bill here is dealing
Yes.
with the
Correct. Yes, you're right. I
investigation
did get
of
off
Judge Rule.
topic. Sorry. I was just thinking back to that. You're right. I apologize. I think that the main question shouldn't be, should we be trying to investigate this judge, but rather, what are we doing about the inadequate aid that we are currently providing to our towns and districts to educate their students?
All right. Thank
That's
you
all
very
I have.
much.
Thank you.
Thank you. Questions for this witness? Seeing none, thank you. Sandra Cannon, please. Ms. Cannon? Okay, I guess Ms. Cannon is not here. I think she may have been, I thought she might have been here earlier, but anyway. All right. Is there anyone else here who wishes to be heard on House Resolution 7? Seeing none, I'm going to close the hearing on House Resolution 7. Pardon? Oh, right. And I'm actually going to take a minute, because for some reason I don't have the next bill in my notebook, and I'm going to get a copy of it.
Was this bill vacated to us? Because it says municipal. RSA
I wish I read. I know. I think. Yeah. All right. Okay. You know what, how you do? How's it down where? This bill originally went to county and municipal, and we got it late. And that, I mean, it's before judiciary, but it was referred to us late, I think, or transferred, and that's why we don't have it.
Are there more copies back there?
There's more copies over there, but you can take have this, you can take this one. No, that's all right. Sure, okay.
Wait. I could stop.
Okay. All right.
Yes.
I'll never say you didn't do anything.
All right. All right. Are you all okay? All right. Great. All right. So I'm going to open the hearing on House Bill 132 FN and recognize the prime sponsor, Representative Ladd. Thank you, Representative.
Thank you very much, Mr. Chairman and members of the Judiciary Committee. For the record, my name is Rick Ladd. I come from Haverhill, New Hampshire, and I represented Grafton 5. That's a number of smaller towns up around Benton, Landaff, Warren, Piermont, and the center being Haverhill. This bill, which I'm presenting today, is HB 132, and just a little background on why I'm sort of out of my wheelhouse by being over here in Judiciary instead of on the other side of the street here in education. I was approached by a citizen in Piermont roughly last March and asked, what do I do when we have a relative that we have not dealt with in this town for years and years and years, and hasn't taken anybody's advice, and is rock bottom poor right now, and they're coming after us to support this individual. And they say there's this statute, and the statute which you have before you that I gave you is 165:19, liability for support. On the back side, it just takes you roughly quickly through that process, which this person was starting to go through with their select board. And this is in the small town of Piermont, roughly 600 plus people living in the town. What it does is that it requires, and this bill was developed when I looked at the last time, it was last changed in 1986, 85 prior to that, where they kind of shrunk it down quite a bit. And it was initiated back in 1925, 1933. So we're talking about the Dust Bowl days and the roaring 20s and what resulted back in the 30s. This person had a relative right there in the same town of Piermont. And the law basically says right now, if there's a relationship, and they talk about the relationship being a father, a mother, a stepfather, stepmother, son, daughter, husband, or wife. And it deals about the poor person that needs that support within that community. And what the select board was tasked to do in accordance with this law right here, it could also be a county commissioner or an overseer of the public welfare, or your welfare officer for your town now, would look at you and say, okay, you may have to help pay for the costs of this person, even though the person's been doing everything contrary to what you believe in, even though you haven't met this person in your community for umpteen months and years. You are bloodline with this particular individual. And so the board then decides whether you have the means, the wherewithal to help. And it says right within it, the weekly income more than sufficient for yourself. And this individual did have income above and beyond, and others in the town did as well, and had been helping, and it had just not done a darn thing. And so when you go further with it, then the people that are conducting that meeting, the county commissioner or the selectman or the overseer, if such person refuses to comply with their above order to help, then the person shall be summoned to appear in court pursuant to RSA 165:19. A hearing is conducted. If the poor person is found to be in need of assistance, and if the relationship is able to render assistance, the court may decree relations shall furnish this assistance. But what happens if that individual refuses? According to the law which you have in front of you right now, they can be deemed in contempt of court, and they can be imprisoned for no more than 90 days, no fewer than 60 days. And if there is no relationship in town to take care of this, it falls upon the city or the town to take care of the individual. So right now, the request you have through this is to delete the whole chapter. It's kind of outdated law. We have a lot of issues going on in communities where people are related, and even those families within are not talking with each other due to somebody maybe doing some awful things. And so that's the gist of what's coming forward to you. This was an actual experience which occurred up there. I do not know what the outcome was. The person's still walking around, so obviously it wasn't put in jail. But it seems to me a pretty harsh, impact on a family that just is, we had these obligations to send our kids to college, so we were doing this and this and this and this. We don't have any more money to put on this person over here, which in fact, we don't want anything to do with, but we're aligned by blood. Thank you very much, Mr. Chair, and that's the gist of this conversation.
All right. Thank you. Representative Moore, please.
Yes, thank you, Chair, and thank you for the question. It says rarely used. Can you quantify rarely?
I have not. When I presented this to the people over across the street at OLS and the researchers, they went through and said, wow, we really don't know much about this. In fact, it really belongs, out of the statute because it's kind of outdated the way this is done. There's so much transiency now in our society, and I'm not saying that we shouldn't be helping people, but I don't think it should be necessarily placed on that family. But I can't tell you specifically when it was last used, if in fact it was even used, other than what I see in what happened at one time in Piermont.
Follow up?
Quick follow up. So this is kind of like one of those antiquated rules. You can't have more than 20 chickens living in your house or something, you know, something ridiculous that nobody ever enforces because it doesn't happen.
We have a lot of this. Actually, if you look hard at our statutes, you're going to come across these things which occur, and somebody digs it out and uses it, applies it once or twice, and here we are.
All right. Representative Horrigan, you had a question?
Yes. Would you believe that this law is probably even older than 1925? I think the thing they found in 1925 is like something they passed as a chapter law rather than as.
That's exactly what it says.
So RS 66-8 is probably much older even than 1925.
Representative Horrigan, you're probably correct.
Yeah.
All right, other questions for this witness? Seeing none, thank you
Thank you very much.
Thank you very much, Representative Ladd. Next, I'm going to call on Stephen Tower, please.
Good afternoon, Mr. Chairman, members of the committee. I'm Steve Tower with New Hampshire Legal Assistance. I sort of head all of our involvement in the local welfare law at NHLA, so I'm sort of our local expert on it. We are not taking a position in favor or in opposition of this bill, but I did want to testify to provide some additional information. Having spoken to Mr. Marsh behind me, who will be testifying later on, I think a lot of what my planned testimony would be duplicative, so I'll just keep it short. In addition to RSA 165:19, which identifies the legally liable relatives and includes this language about being able to enforce the liability, RSA 165:20 also allows towns to be reimbursed for expenses that were incurred from legally liable relatives. So were this section of the statute to be repealed, I think RSA 165:20 would also need to be amended. Beyond that, I'll just state that back in 2021, I sent out a number of 91A information requests to towns to ask and just kind of get a feel for how the local welfare law is working in different parts of the state. I sent them out to major municipalities and then a handful of the smaller municipalities. I sent out about 50 in all. And one of the questions I asked was, had any town ever recovered expenses from a legally liable relative in the last 10 years? Under RSA:20, and all of the towns that responded stated that they had not. So I think at a minimum, there's not a lot of going to the courts to enforce the legally liable relative. But as Mr. Marsh will probably testify, towns do sometimes use the existence of the statute to call up legally liable relatives and say, hey, can you take this person in, give them shelter so that we're not paying for it? If you don't, we technically could go after you, even if a town generally won't. So I think that's the extent of my testimony. If anyone had any questions, I'm happy to answer them. But
You know, I'm sorry, could you just, I think Representative Ladd referenced it, but to be honest, I've forgotten exactly the language you used. Who are the people that are, what is the scope of the relatives relationship that makes you subject to the statute?
It's
oh, thank you.
mother, father, son, daughter, brother, sister, I believe.
Okay.
Okay.
Okay. Right.
And there are certain situations where a person who may have that relationship connection, but say, you know, they grew up in an abusive household and they haven't spoken to their family in 30 years, or perhaps the legally liable mother of somebody, their child is battling an addiction and has previously taken all of their jewelry and pawned it. And so there's, you know, a breakdown in the relationship in that way. So sometimes there isn't that tight family connection that I think it may be imagined when this bill was passed. But I'm sure everyone could imagine the situations where maybe not everyone in a family gets along super well.
All right, questions for this witness? Seeing none, thank you very much, sir. Next, I'm going to call on Todd Marsh, please. Yay. Yes, good idea.
Good afternoon, Honorable Chairperson, members of the committee. Yes, my name is Todd Marsh. I am the president of the New Hampshire Local Welfare Administrators Association. The methodology section of the HB 132 states the following. However, according to the Local Welfare Administrators Association, the provision is sometimes used but infrequently. I am the president of the New Hampshire Local Welfare Association, as I stated, and I will plainly state I am not aware, nor is our board of directors aware, of being formally consulted regarding this bill. So I appreciate being here today. At a time of increasing assistance expenditures for municipalities, we should not eliminate a reimbursement option to municipalities that has existed for many decades. Although it may be used infrequently, it is used frequently enough to maintain an important reimbursement option for municipalities for local taxpayers. It is vital to allow municipalities to seek reimbursement from legally liable relatives in the line of, as it was indicated, father, mother, stepfather, stepfather, stepmother, adult son, adult daughter, husband or wife, as long as reimbursement does not cause financial hardship on that legally liable relative, meaning the reimbursement does not cause an inability for that relative to pay their basic living expenses. In that situation, reimbursement is not sought. The current law, the value of the current law, beyond simply the actual reimbursement, but the value of it is the potential a municipality could seek reimbursement from legally liable relatives. Why? Because the close family members mentioned are often likely to assist their family member in need with just the prospect of the municipality could seek reimbursement. Types of assistance when reimbursement is either discussed or actively sought. The most are unhoused situations. As indicated, we try to be very sensitive about that. Is domestic violence involved, sexual harassment, violence? So we practice situational flexibility. Municipal welfare practices flexible decision making, as I indicated, when deciding to use legally liable relative law, which is often based on family dynamics, including known or unknown whereabouts of family. We're not going to spend 2 months trying to locate an adult son that lives in Arizona somewhere for reimbursements, meaning we may not contact, and we likely will not contact a family member if a resident is seeking assistance with $125 for an electric bill because of a disconnect status. But we may, for emergency housing, extended rental payments, burial cremation assistance due to the cost. Maintaining the option for municipalities, including the taxpayers that pay for assistance, to seek reimbursement is important to minimize cost to taxpayers with minimal effect on the applicant because it has no effect on the bearing of the decision that we make on the applicant. The association representing the municipal welfare offices throughout the state ask you to oppose this well-intended, and I believe it is, but I think too many but full of consequences bill in front of you.
All right. Representative Smith.
Thank you so much for being here. I'm a little confused and maybe I'm tired.
Yeah,
No,
too.
actually, I am tired, so that I'm not confused about. Can you tell me, you can go back 2 years, 5 years, 10 years, 20 years, exactly how many times welfare administrators have in fact used this to collect money?
I cannot give you numbers because it's not collected. What I can state is that having consulted our board of directors, which is made up of both large and small municipalities, that they were very clear that we should be opposing this bill, that it may not be used on a daily basis, but it is used. And oftentimes it's the mention of, as it was indicated earlier, that this law exists that may result in a family member, a close family member, rethinking and deciding to potentially assist their family member who is in need. And if they cannot, then the person will come into our office.
If I could just follow up, I read the fiscal note. I read it twice. I then actually gave my copy to someone else, so I maybe, because I'm tired, I don't remember. But it seemed to indicate that there was basically what is known in the vernacular as de minimis financial return in this. Is that incorrect? Are you saying that the only the only thing that this is good for is to remind people, if reminding people that they have an obligation to their family, if that's not quite enough, but to say to them they might be, I guess the language from the period is they might be put in the hoosegow, that causes them to do something that they wouldn't otherwise do?
I would state that if this bill was to pass,
Yes.
there would be a cost to the municipalities due to the reasons that you indicated. There are family members. There are family members that do assist because of the law, because of a letter that may be sent out. They absolutely do.
But then why can't you give me any numbers to tell me how much money has come in because of this?
Right. It's challenging to do
I'm
because
sorry, I apologize.
No, that's okay.
I appreciate the I appreciate the question. Because of the nature of local welfare throughout the state, it would be very challenging to get those numbers, especially in the time that I had. But we do represent local welfare departments throughout the state, large cities, small towns. Some towns use it more than others, but it would be at a cost to. Can I give you a quick example of a situation, if you don't mind?
Right.
Okay. Thank you. I'll use the city of Rochester. If an adult son comes into our office, unfortunately seeking burial assistance or cremation assistance for his mom, we will, after we have a good conversation, we will thoughtfully remind it is in our application of the law, and that they do have a right to come in if they cannot afford to pay themselves. And however, I would say about half the time they come into our office because I think they have a chance to think and pause. And if they can self-pay themselves, they will. Whereas if the law did not exist, it could change that dynamic.
Right.
And if they can't pay it, they can come into our office. They absolutely.
All right, Representative Morton and then Representative Tur.
So, so you say that it's not collected as far as the numbers, and this applies to people of every age. That being said, I'll give some statistics. We know that 10,000 Americans every day turn 65, and we know that there's a growing number of elderly people, and 70% of people over the age of 65 will need long-term care. That would be something that would fall into this. Only 16% of people above the age of 65 have insurance to pay for that. A very small percentage, probably less than 10%, can financially afford it themselves. So that's where Medicaid would kick in.
Is there a question here?
Yeah, absolutely. Because the vast majority, I do long-term care insurance for a living. So the vast majority of people who receive care, and some younger people as well, get that care from family members. So is your point being that the people find out that their family member needs care because they've been, they haven't been in contact with each other for a while or whatever, and that's helped put people back together and help them get that care, because the vast majority do get care from family members statistically.
Yeah. I will say that, well, in a past career life, I also sold long-term care insurance 20 plus years ago. That was very difficult to sell, by the way, because nobody believes they're going to a nursing home. And anyway, I should state that New Hampshire local welfare does not pay for long-term care. for that kind of service. So I think that would not be an issue.
All right, Representative Turner.
Yeah, thanks. Thanks for taking the question. I'm just curious, given the age, I guess, that we've heard of this law, how does it interact with sort of the programs that have been put in place, particularly at the federal level since then, like TANF and the other supports that are meant to sort of supplement people's needs?
Oh, thank you for the question. It does not directly interact with TANF and state services. It is more targeted towards local welfare.
Representative Birch.
Thank you, Mr. Chair. I want to follow up first with Representative Smith's question, because the way this seems to work is if somebody's asked to pay and doesn't wish to, they shall be summoned into court if you folks or commissioners, whoever, request it.
Right.
So do we have a number of how many people have gone through the court process? That should be easily determined.
Right. I do not. I do not. I do not have access to the individual municipalities. If I had more time, perhaps we could come up with that. We just don't have
Do
those
you have a
numbers.
sense whether it's in 1-digit, 2-digit, 3-digit number?
As far as municipalities,
As far as people
that
being
actually go take people to court,
summoned to court under this section.
yeah, I would say municipalities that follow through, not many.
So would it be a
probably
would it be a fair characterization of
Right.
your testimony that municipalities kind of like this law because even though it's very unlikely that they're ever going to try to carry through on it, it gives them a little bit of a hammer to, for lack of, this is my term, not yours, but for lack of a better term, to some extent at least coerce or persuade people that, you know, you ought to pay up because if not, we could take it to court.
Right. So it's situational, right? And the reminder that the law exists does help our offices. When I say help our offices, I also mean local taxpayers.
Okay. All right.
I could,
Representative Birch, go ahead.
Without a hammer.
to follow up this gentle letter, I assume it says to, let's say, a 90-year-old person that if you don't help out, including if you refuse to go back to work, you will be subject potentially to a mandatory jail term. Is that the kind and gentle letter you're referring to?
Based on the statute, it could be done. Based on reality, and I've been doing local welfare for 21 years, that does not happen.
All right. Yes, Representative Tripp.
When you first started, you said which RSA you operate under. Could you tell us that one again?
Yeah. RSA 165, and the relative liability is RSA 165:19.
Say again.
RSA 165:19
Oh.
is the legally liable relative.
I thought that was a different one. Sorry.
All right. Any other questions for this witness? Representative Manos.
Thank you, Mr. Chair, and thank you for taking my question. It sounds to me from your testimony that there's sort of an informal process that goes on here, and I'm curious about that. So in this informal process, let's say you have somebody who's homeless, maybe with some mental illness problems or addiction problems, and there's a question of domestic violence or not. It sounds like it can be cyclical, that the person can maybe stay put with the sister for a while and then they leave again. And it's, who makes that who's making those judgments? It sounds like it's almost, for lack of a better word, hand holding. And I'm just curious about that.
So just for some clarification, if a person who is unhoused or in a challenging situation is bouncing or including staying with a sister, how would we manage that? Or I just want to make sure.
That's my question. It seems like there's an ongoing informal process over time, and people are exercising judgment and making judgments, and arrangement works for a while and then stops working. And
right. Yes, that absolutely does happen. Where in our field we often call it couch surfing, and that's what people call it who are unfortunately going through those situations. And if someone's staying with a sister in that situation where local welfare is not paying anything, and I will state to further clarify, I think it's if someone approaches our office and they're 18 years old, 19 years old, stating, "Oh, my mother just kicked me out," right? And maybe that adult has a child. We will listen to the situation because we certainly do not want to refer them back into a harmful situation, even if it saves money, right? That's not okay. But if their story sounds like, maybe we should make a phone call to that parent, we may very well do that. And we could cite the law. Normally, we don't need to. Normally, I can say, hey, your daughter's here with your grandchild. Yeah, is it okay if they come back? Oh, absolutely. Right. But we have that law in order to point to if we need to. And what we do, yes, judgments are made because we're constantly solution finding. What local welfare does is not categorical assistance. Whereas in TANF, Medicaid, it's more. These are the numbers, and the decisions are primarily made by the numbers. In local welfare, which is what I enjoy about it, actually, the numbers matter. The numbers matter. The budgets matter. But we're going to ask the question: what's going on? What's your situation? Because that matters too. It helps us to problem solve.
All right.
So that's how our local welfare works.
Right. Representative Morton.
Yes, thank you, and thank you for the question.
You're welcome.
So Harbor Care, is that another resource rather than pushing it back on the towns or United Way? Or, are there other resources, or is this either, your brother helps you, or, the town's going to have to pay for it and we're going to go after you?
So if we can reasonably refer elsewhere, we will. If timing and the nature of the emergency makes it okay to do so, we will. But we need to determine, what's the timing? Is there truly a resource that's available at 4:00 on a Friday? And we are the ones with the legal obligation. United Way and some others, not necessarily. They're not. But we will refer when it's reasonably possible to do so. We collaborate with many helping providers, and sometimes it's a puzzle of assistance when we can do that. Sometimes it takes time to do, but if we can refer, we will. But when it comes down to it, literally, I try not to use that word too often, but the buck stops.
All right. Thank you. Any other questions? Representative Katab.
Thank you, Chairman, and thank you for taking my question. I just have a question. So I'm not sure if you're familiar with the Jenness v. Emerson case from 1844, which is, I think, what...
Absolutely not.
Okay.
So
I think it's a New Hampshire Supreme Court case, which basically said that the families... Would you believe that it's a New Hampshire Supreme Court case that basically said that a family member is responsible, and including a child of a parent is responsible to take care of their parent? It was a case that the child didn't want to pay for the parent's welfare, and I was told back in 2023 that that's where this law came from, and that even if we repealed it, that common law basically said we had to do it anyway. So do you still believe that would be the case, that common law would kind of just make us do this anyway, even if we repealed this?
Well, not being an attorney, I need to be careful with it with the answer to that. I will say this: in the situation that I mentioned earlier, adult son comes in, could be a daughter, regarding the passing of his mother, right? And the question is in our application regarding legally liable relatives. It's on every application throughout the state, okay? One way I may phrase it, I may say something like, you know, the way the state of New Hampshire looks at this is family first, if possible. If possible. And if they can't, that's why we exist. And so we put it out there, and the person decides, all right, can I reasonably do this myself? There are family members that simply, who could assist, who just, but for whatever reason, you know, decide not to.
All right.
So I think I overly answered your question.
All right. Are there any other questions for this witness? Seeing none, thank you very much.
I appreciate it. Thank you.
All right. Is there anyone else who wishes to be heard on House Bill 132?
Mr. Chair, my friends in the Municipal Association are out back, and I'm just wondering if they have an opinion on this bill and if they'd like to weigh in on it. I would certainly like to hear their opinion.
Anybody else, anybody here at the back of the room that wants to weigh in on HB 132? They seem to be indicating no. Whoop, I'm sorry. Are you coming up? Yeah, fill it out while you're gone. That's fine.
I, for one, care a lot about what the Municipal Association has to say, so I'm glad they're here. Thank you.
Good afternoon. My name is Sarah Burke Cohen. I am from the New Hampshire Municipal Association. And thank you for that, Representative Alexander. I appreciate it. We do oppose this bill. In the fiscal note, New Hampshire Municipal Association, I think Representative Smith mentioned, we don't see that there's a huge cost shift if this bill passed. However, we do agree with the local welfare association that allowing it to still be in place does assist with some welfare officers in ensuring that some of the applicants get assistance from their family members at the first step and not the town at the first step.
All right. Any other questions for this witness? Seeing none, thank you very much. Anyone else that wishes to be heard on HB 132? Seeing none, I'm going to close the hearing on that, and I think we are done, which is good because I need to get to finance just for the members of the committee. It will be in the notice for this week, but don't forget. I mean, obviously we have session tomorrow, but we're going to have an executive session next Monday starting at 1 p.m. And I have to exec a bunch of bills. And the other thing I wanted to say, just for I'm sure Representative Smith has arrangements for her caucus, but for my caucus, we're probably going to have another Zoom meeting this Sunday night, and I'll send out a notice on that for the bills we're going to exec on Monday. All right. With that, thanks very much, everybody, for hanging in.